May I be permitted to mention one matter, my lord? Item number 114 of the monthly list, my lord. In this, for the upgradation, my lord, actually, contempt case has been filed in this. So, an urgency is there, my lord.
Original side or appellate side?
Original side, my lord.
Lordship, may I permit you to mention, Lordship, regarding restoration application, your Lordship. Appellate side.
But may I be permitted to mention item number 137 of the monthly list when praying for upgradation? It is a departmental appeal against 263 order. But the 263 order has been given effect to, assessment has been passed, and it has attained finality at the ITAT stage.
So it has become
infructuous, my lord.
Who appears
So
for
Mr. Samarjit Roy Chaudhary is appearing. My lord, I have informed him that I'll be mentioning.
All right. Tomorrow to be mentioned.
Right.
So this is a matter
I'm grateful.
reconstruction. Lordship,
No, the department, they are verified. You have filed an application for modification of a judgment, which was rendered about 4 years before by Honorable Justice Tandon and Honorable Justice Ravindra Samanta. So, another thing is, this is against an order of the tribunal.
Lordship.
We don't have determination.
Lordship.
So if the application for modification has to be listed, then a bench has to be constituted because both honorable judges are not available.
Lordship.
So we cannot take up or we cannot permit you to file this.
No, Lordship, I'm paying for only original certificate. Matter has been disposed of. I'm paying for only original certificate copy, but file could not be traceable before the amendment. That's why I mentioned I'm not praying for any modification.
See, because we don't have determination on that subject, courtroom number 4 will have determination. You have to take leave from the court for reconstruction for the purpose of obtaining certificate copy. But you have filed a CAN application also.
No, Lordship.
No.
Nothing, Lordship.
Then you mention before court number 4 and say that this is the problem. So if Lordship permits for reconstruction, it will be reconstructed, and then your application for certificate copy will be.
Lordship, can you pass a one-line order? Just because Lordship file has been disposed of, Lordship.
No order can be passed. No?
May I be permitted to mention one matter for hearing, my lord? My lord, notice, yes, my lord, group 6 matter.
Group 6. Let us see. Please.
My lord, notice has already been served up on the appellant. My lord, I am for the respondents.
Yes.
My lord, I am mentioning my own case. I am appearing in person. This is an open and shut case at this moment. Though 5 years have been passed by, last 1 year have been passed only in mutual settlement, but no mutual settlement was done.
It is a service matter?
It is a service matter, my lord. I am not getting salary for 5 years. It is written in the order.
In which department you are working?
I was working in NTPC, my lord.
NTPC.
NTPC.
And what was the order passed against you?
It was CRS, means compulsory retirement because of inefficiency.
All right.
But no inefficiency is there, nothing.
And the writ petition was dismissed?
Writ petition was not dismissed. I was sent to Delhi, where I have never worked. There is no cause of action in Delhi.
Is this an appeal or a writ petition?
This is an appeal, but appeal is against the order for going for Delhi. That order was not on merit. Order was for jurisdiction.
No, order was passed in which case? What is the case number?
Case number was 7832. WPA 7832 of
WPA.
WPA.
What happened to that writ petition?
That writ petition was dismissed for jurisdiction, not for merit. I was asked to go to
And you
Delhi.
filed an appeal?
Then I filed an appeal because I have never worked in Delhi and there is no cause of action in Delhi.
But the head office of NTPC is in Delhi.
Head office is in NTPC is in Delhi.
Your salary you received in Kolkata?
Salary I received in Kolkata. Everything is in Kolkata. The cause of action is in Kolkata.
Sir, you listed to be mentioned. Who will appear? Who's appearing for the NTPC?
For learned senior advocate Mr. Vikas Bhattacharya and learned senior advocate Mr. Somo Adhikari. And there is DVC also, because the cause of action arose in DVC. For them, learned advocate Mr. Partha Tarafdar. And there is an amicus curiae, my lord, also, a learned amicus curiae.
For your, to assist you.
Amicus curiae, my lord. And he is Mr. Partha Bhattacharya.
What shall we do? No, we list it under the caption to be mentioned. Then let all the advocates appear. See, normally what happens is we entertain mentioning upon notice. Because you are party in person, probably you will not be able to find them. So we will list it on Monday. Monday we will list it. Let them appear. Then we will see what can be done. The amicus curiae mobile number is there.
In the order, then at least some intervention.
My lord, group chief matters for hearing, my lord.
Yes.
See, only one. Item number 94, I mentioned day before yesterday, you also directed me to communicate it to the Mrs. Manasi Mukherjee, but she has withdrawn her name because she became the senior standing counsel, so she's no more. So I need to communicate it to the new advocate or department because
Department. You please take down item number
94
94.
monthly list.
Monthly list. The learned advocate, you are for the appellant or respondent?
I am for the respondent.
Respondent
Issue is that my lord, this duty paid under the Sugar Cess Act.
It's a covered matter.
That is why your lordship directed me to communicate.
Learned advocate appearing for the respondent assessee submitted that the issue involved in this appeal is covered by an earlier decision. The learned advocate was directed to inform Ms. Manasi Mukherjee, learned standing counsel who appeared for the appellant department. The learned advocate has informed the court that she is no longer appearing in the matter. Therefore, the learned advocate for the respondent assessee shall serve notice on the appellant department, enclosing a copy of the judgment passed in an earlier case. List the matter in the daily list. I give a date after 2 weeks. But why you can't appear? Because you have become a senior.
My lord, I have written the brief because what happened, my lord, the matter was pending here. We filed. Immediately, then in the meantime, my notification came. At that moment, the stay application was not settled by the then senior, who is still now the senior. But the junior has changed. So junior has forwarded the stay application. I immediately filed because notification came. So immediately I filed the memo because there would be a delay. But the stay, since not vetted and settled, could not be filed, my lord. And then it was pending for quite some time. The senior has sent again. I have been informed that senior has sent, but that was recently waited. Last week has been waited. Though all the procedures and the papers.
At least orally you inform them.
Yes, I have very much.
They will send notice.
Yes, because I have been communicating with him 24. He cannot deny. Since my notification came, I informed everybody.
No, you orally.
I am not aware that she has withdrawn from the particular case.
No, I have informed.
Yes.
Original side daily list item number 1 to be mentioned.
Lords, I'm praying for leave to withdraw the appeal.
Why?
I have instructions from my.
Show that first. We have heard so and so. The learned advocate appearing for the appellant seeks leave to withdraw this appeal, and in this regard has placed the written instruction given by the appellant to the learned advocate by a letter dated 8 July 2025. Placing the said letter on record, the appeal is dismissed as withdrawn. The substantial questions of law suggested are left over.
Item number 2.
Lord, in item number 2, 3, and 4, I am appearing for the appellants, my lord. I have instruction to withdraw this departmental appeal in terms of CBIC instruction dated 6/8/2024, my lord.
You have got written instructions?
Yes.
The learned advocate appearing for the appellant department has written instructions from the department by a letter dated 4 July 2025, seeking leave to withdraw this appeal. as the monetary involvement in the matter is below ₹2 crores. Accordingly, appeal stands dismissed as withdrawn, and the substantial questions of law which were admitted for consideration are left open.
Yes.
In all three matters, you are appealing.
No, I am 3 and 4.
Who will appear for 2? Anybody?
Only 3 and 4. Om Shakti.
That one. Paper book, their name will be there. Then you enter. KP needs for the appeal.
For admission of tax matters, item number 5.
For the respondent lordship led by Mr. Majumdar in this matter.
Lord, here is the addition, my lord, under section 68. Lord, the assessing officer's case that, my lord, the assessee did not file any document and did not prove the, my lord, genuineness, seriousness and identity of the, my lord, shareholding companies. Notices has been served. The, my lord, assessment order passed. Thereafter, my lord, CIT appeal also, my lord, affirmed the assessment order. Thereafter, my lord, the assessee file appeal before the learned tribunal. And before the learned tribunal, my lord, they have filed compilation of papers. From compilation of papers, my lord, the learned tribunal was of the view that, my lord, the 3 limbs have been proved by the, my lord, assessee. Now, your lordship.
Did a remand report was called for? No.
No, my lord, there is no remand report called for.
Page 78, para 8.
But actually, my lord, tribunal was of the view that the, my lord, the company, though invested to the, my lord, assessee, my lord, they have sufficient, my lord, fund. But that is the, my lord, main crux of the, my lord, tribunal's consideration.
No,
but
the thing is, identity has been proved,
my lord,
creditworthiness has been proved,
now,
and genuineness.
my lord, the problem is that, my lord, the directors of the, my lord, companies, but they did not appear. But the papers is showing that, my lord, the company has sufficient fund.
Net worth is some crores.
That is the, my lord,
Page 80, para 10.1, the 5th line. We also that they had complied also, lordship. Page 80, para 10.
We also noticed that the summons under 131 had to be issued to the directors who have appeared before the AO, submitted all documents to establish identity, creditworthiness.
now, my lord, this finding, it means contrary to the finding of, my lord, the assessing officer and, my lord, CIT appeals. My lord, may I?
Let us see where the CIT appeal says.
Yes, my lord.
They have not complied with.
CIT appeals order, my lord, from page 13. Now, my lord, page 16. To verify the genuineness of such transaction and to verify the identity and the periodicity of shareholder companies, notice under section of the Act was issued to directors of the shareholding companies of the assessee. They were asked to appear personally before the undersigned and to produce furnished detailed document in support of the justification for the investment made by them in the assessee company and other details as asked for, but none of them appeared before the undersigned. After that, letter was issued to the assessee on 25/2/2015, informing that the said facts and was asked to produce the directors of the shareholder companies. So, while this letter, assessee was asked to show cause as to why share application money received by it should not be treated as unaccounted money introduced in the books of accounts of the share application money. SSC was also asked by this letter as to why the said share application money should not be treated as unaccounted cash credit, such as SSC failed to put forward any explanation till date for date of passing this order. These findings is contrary to the finding of the tribunals. There were page 17, page 17, second paragraph. In this case, there was no compliance either from the end of the SSC company or from the alleged subscriber company.
Then how does the tribunal say that they have responded to this?
They had complied.
I am led by Mr. Mitro.
Finding of the tribunal is not, my lord, matching with the other facts that has been recorded by the assessing officer. my lord.
Actually, what you just now read at page number 80, 616, is an extract from the assessment order.
Yes, that is the extract of the assessment order.
And where is the finding of the CIT appeals on this?
That is at page,
CIT appeals finding.
finding is page 49.
ওটা জজ সাহেব ইয়ে করেছে।
No, where does he say that the directors did not appear? He has extracted judgments after judgments.
Yes, that has been recorded.
That
I tell your lordship, this is a below tax limit matter. Identical questions when raised before your lordship, there is an order passed by your lordship. The lordship isn't pleased to dismiss the appeal on the ground of monetary limit. Identical question.
They will say it falls under the exception.
But that is the exact submission that was made in the other matter, and that's a reported decision, my lord.
Actually, my lord, this CIT appeal, my lord, cited, my lord, thousands of judgments. And
He has not given any
Not is not on the pat of the coin.
No.
But my lord, the tribunal on the other hand,
tribunal says that they appeared. You please
That
see
is,
page 80,
my lord,
para 10.1.
assessing officer said not appeared.
Ah,
CIT appeal did not say anything. Tribunal says appeared.
and all the documents that has been
No, my lord,
produced.
SSC file
but
confirmation.
the directors of the assessee company appeared, not the share applicants.
Correct. But the assessing officer says,
But that's an incorrect.
oh, okay.
But it is all about the appearance of the share
Verifies
applicants.
genuineness, identity, credibility, shareholders of the SSC company. Notice under was issued to the directors of the share.
Yes, yes, my lord.
That is not required.
That is not.
Not in all cases. Please come. It's appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 is directed against the order dated 21st February 2024 passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, within bracket Tribunal, in ITA number 250/KOL/2020 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page number 5 and 6 of the state petition, ground numbers 1 to 4, 5 not required. We have heard so and so. The short question that falls for consideration is whether the learned tribunal was right in allowing the assessee's appeal and setting aside the order passed by the Commission of Income Tax Appeals 10 within bracket CITA dated 2/12/2019 2/12/2019. The tribunal has committed a mistake saying it's 263 order. In an appeal,
It's an appeal.
filed by the assessee, challenging the
May I take your lordship's kind leave, my lord?
assessment order dated 11/3/2015, passed under section 143 within bracket 3 of the Act. We have carefully perused the findings recorded by the assessing officer, the CIT appeals, the assessing officer, and the order passed by the CIT appeals, and the conclusion arrived at by the learned tribunal. The only reason assigned by the assessing officer for making the addition under section 68 is that the assessee did not prove the creditworthiness of the shareholder, share subscribers, the genuineness of the transaction, and the identity. In this regard, the learned tribunal has carefully examined the documents which were filed by the assessee in the form of a paper book, which contained confirmation letters of all the share subscribers, stating that they have given the share application money, and the source of such share application money has also been brought on record. Therefore, the tribunal was justified in coming to a conclusion that the source of source has been explained by the assessee company. Apart from that, summons under section 131 of the Act were issued to the directors of the assessee company who have appeared before the assessing officer and submitted all documents to establish the identity and genuineness of the and creditworthiness of the shareholders and the genuineness of the transaction. Apart from that, the tribunal found that the share applicants have sufficient funds and they have explained the investment. And therefore, all the three ingredients proved, and the owner shifted on the department, and the department was not able to dislodge the burden of proof cast upon it. The tribunal, after noting the factual position, has referred to the various decisions of the coordinate bench of the tribunal, allowing the appeal. In the light of the above, we are of the view that the matter involves a matter is entirely factual and no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, appeal fails.
Item number 6.
One of the issue concerns originally a classification dispute, so there is a preliminary issue of admissibility. Your Lordship will kindly come to the supplementary affidavit. I apologize. I know several questions have been framed.
But of particular note is if I take your lordship to ground number 7 in page 4.
It is
Supplementary.
So your contention is the earlier round, what was remanded was not to redecide the issue of classification, but the tribunal did so.
The tribunal and the de novo adjudicating authority. So the very limited point.
So it was remanded to the adjudicating authority.
That's right. Because this honorable court was of the view that the.
You have served this on.
Yes, it's been served last month. So the very limited question with which I have approached this honorable court is simply on the subject of whether the judgment of this honorable court in 2010 bound the subordinate authorities, being particularly the tribunal and the de novo adjudicating authority. Now, how your lordship answer, or how this honorable court answers this question, whether in the affirmative or in the negative, in my humble submission, will not directly, or at least proximately, impinge on the issue of classification, or subsequently the exemption notification availed, or subsequently the issue of rate. So the question that I'm raising before this honorable court is far removed or remote to the issue on rate. Now, there is another question on natural justice. There was an inordinate delay of 7 years. The remand proceeding was supposed to be concluded within 12 weeks. They took 7 years. And the assessee took a specific point before the tribunal that this delay has prevented it from supplying certain evidences which this honorable court may have mandated in the remand order. So the honorable tribunal, in a single line observation in the 41-page order that it has passed, simply made the observation that the de novo adjudicating authority has complied with principles of natural justice. So the second query was on natural justice. So these are actually the two issues which have been agitated, and it's mostly to do with procedure. Now, since the original dispute pertained to classification, the line of argument could be adopted, and this used to be the position before, that if ultimately a question on classification arises, or no matter how this question is answered, if it has some sort of direct or indirect impact on how the question on classification is to be addressed, therefore this is a matter that should go to the Supreme Court. Now, since 2019, the law has evolved. I would say that even before 2019, there have been some precedents here and there, sporadically, but in 2019, after the judgment in Motorola, there's been a specific criteria laid down that assessees have to go through now to assess whether the appeal lies directly before the Supreme Court or before the Honorable Court, even in cases where there's classification or rate of duty, taxability, as the case may be. And since that decision in 2019, there have been several other precedents that have followed where they appear, at least in my understanding, to have expanded upon it. It appears that the Supreme Court, unless there's a question directly on rate or directly on the evaluation, they are not going to be very keen on entertaining the appeals, especially if it's a question that is a precursor to that final question. So I'll take your lordship to the principle, and then I'll take your lordship to the judgments. So if your lordship comes to the compilation which I have placed on record on the previous day, there's a compilation of precedents which I have submitted. And in particular, my lord, the Motorola decision is in page 12 of the compilation. Now, the relevant observations, your lordship will see, begins from page 14, paragraph 10 onwards.
Yes.
So, my lord, in paragraph 11, there's the reference to Naveen Chemicals. In Naveen Chemicals, at the bottom of the quotation in paragraph 11, if I may place it in the last 7 lines, your lordship will see there is a reference to remoteness or the proximity of the question to the question of interest.
A dispute as to classification of goods.
So if your lordship sees the last 4 lines in the quoted paragraph 11 of Naveen Chemicals in page 14. It starts with the words, whether the value of goods for purposes of assessment is required to be increased or decreased is a question that relates directly and proximately to the value of goods for purposes of assessment. So proximity is a criteria that was looked into in Naveen Chemicals. This became a point of reference. If your lordship turns to the next page on page 15, and your lordship will see paragraph 14. So this is the other condition. It could thus be seen that this court has found that when an order of the appellate tribunal would go beyond inter se disputes between the parties and may affect a large number of cases, such an issue will be one of general public importance. It has further been found that certain questions raised or arising may require interpretation of the Constitution. It is held that only such constitutions of general public importance alone are required to be decided by this court. It has further been held that by the very nature of a question raised or arising, the same necessarily has to involve issue of law going beyond the inter se parties' rights and extending to a class or category of assessees as a whole. So this is one condition, and as I shall seek to argue, this is actually a standalone condition, but it perhaps may also be read together with the condition on remoteness. That the summary of the entire position your lordship will find in paragraph 17. Reverting to the present case, it could clearly be seen that the only question that is involved is whether the assessee had violated the conditions of the exemption notification by not utilizing the imported materials for manufacturing of the declared final product and was therefore liable for payment of duty, interest, and penalty. Neither any question with regard to determination of rate of duty arises, nor a question relating to valuation of goods for the purposes of assessment arises in the present case. The appeal also does not involve determination of any question relating to the classification of goods, nor do they involve the question as to whether they are covered by the exemption notification or not. Undisputedly, the goods are covered by the said notification. The only question is as to whether the assessee had breached the conditions which are imposed by the notification for getting exemption from payment of the customs duty or not. The appeals do not involve any question of law of general. So we come back to the inter se rights. The appeals do not involve any question of law of general public importance, which would be applicable to a class or category of assessee as a whole. The question is purely inter se between the parties and is required to be adjudicated upon the facts available. So there's this twin condition test, which was laid down in Motorola. Now, your lordship will see this has been subsequently applied and reapplied in several proceedings over the years. And in recent times, wait a minute. So Motorola has been subsequently applied. So if your lordship sees the decision in Such Silk International, this is a 2022 decision, the Honorable Apex Court, and the relevant paragraph, paragraphs are paragraph 5 and 6. So, my lord, again, here there's a play on the remoteness factor. Even though the facts are different, this line in paragraph 6, in the present case, the dispute also is with respect to breach of condition of notification, which may ultimately lead to subsequent demand of duty or imposition. But that itself cannot be said to be a dispute with respect to valuation. So this notion that ultimately, because this has a knock-on effect on classification or valuation or rate, that therefore the matter should go before the Supreme Court is no longer the position following these decisions. And subsequently, Asian cable ship has been applied in this case, and Shriram refrigeration in page 5 of the list that I've given, your lordship will see. This opens it up even further if your lordship sees the language, particularly paragraph 6 if your lordship sees. This is again another set of facts, but your lordship will see how the principle has been applied.
Yes.
Now, if your lordship comes back to the compilation, page 2 of the compilation, your lordship will kindly turn to. So this is one of the latest applications of this decision. And your lordship will see this was an out and out case on classification. There are only a few lines, so I've brought the tribunal order as well. That's in page 3. That is the tribunal order in page 3, my lord. And it took me some great pains to obtain the High Court judgment that is separately provided in your lordship's file. That's the decision. Yes. This was submitted on the previous day, my lord. Paragraph 3 onwards, my lord.
But Supreme Court in this Gokul Enterprises did not discuss facts.
Did not discuss facts.
It says it's covered by Motorola.
It's covered by Motorola. Now, to get some sort of comprehension about why it said what it said, I'll try to explain what the original case was. This was to do with palm oil, which was being imported by the parties in question. And there was some partial processing that was done. So the assessee had declared it as an industrial chemical. And the department was trying to say that the processing that's been done, it's not enough to take it to an industrial chemical. Rather, it was still a palm oil derivative, and that it retained its natural properties, and therefore it had to be classified in one way. So ultimately, the third member, so there was a split decision in the tribunal, matter went to the third member. The honorable third member made the decision that the ester value, which is a component in the palm oil derivative, was very high. And so it indicated that it was more a natural product than an artificial product. And so the classification was decided against the SSC. SSC filed an appeal before the High Court. The High Court simply said, well, this is a classification dispute. Ultimately, it's going to impinge on rate, so we cannot entertain it. And so the matter goes to the Supreme Court, and the Supreme Court, in 4 or 5 lines applying Motorola, sends it back. So in paragraph 3 onwards, your Lordship will see what the Honorable High Court has said, the Gujarat High Court. And your Lordship will see this is more or less the interpretation that's been followed for many years. But it appears that there's a change in the way the Supreme Court is witnessing this.
So the question of law involved should go beyond the interested parties.
That's right. That's one.
That is one of the. And the other expression used is
remoteness or proximity.
Relates directly and proximately to the value of the goods for the purpose of access.
I have to satisfy this court that at least one of these conditions or both of these conditions have been fulfilled. Now, in order to gauge what has occurred in this particular case and what question and why these questions arise, I would pray that your Lordship kindly come to the 2010 judgment of this Honorable Court, which concluded the first round of litigation, from where this entire second round has emerged. So that is in page 16 of the compilation. And the relevant observations are from paragraph 3 onwards, page 17. Now, if your Lordship comes to paragraph 5, your Lordship will see what sort of arguments were actually made there. This becomes relevant for appreciating the tribunal order. So your Lordship will see Mr. R.K. Chaudhary for the petitioner has principally made the following submissions. Provisional assessment was made on or about 15th April 1999, but no final assessment was ever made. This was actually one of their main arguments. So all these goods, so the entire consignment batch of 19 bills of entry, all the goods were provisionally assessed and released. The original adjudicating authority initiated a section 28 proceeding directly without completing the finalization. So this is the ITC principle that show cause proceedings for short payment cannot be initiated unless the assessment proceedings are concluded. So irrespective of what had happened in the past in Mumbai relating to earlier consignments, one of the points that they had taken and agitated was to do with procedure. And they challenged the jurisdictional aspect of it. And that's one of the reasons why they came to the writ court. The next argument was, your Lordship will see in subclause D, the product imported were eggs with a live organism or embryo. This live organism or embryo, upon nurturing and incubation, became prawn feed. It was always prawn feed. At its infant stage, and the product after nurturing and incubation was not something different from the product imported. And then in E, he says, test reports during provisional assessment are not made available. So your Lordship will consider the period is 1998 to 2000. This is being decided in 2010. And it's being informed to the court that test reports have not been provided, provisional assessment has not been finalized, Section 28 proceeding has been initiated, whereby they have opened up interest, penalty, confiscation, and all that. And there's, of course, the issue of classification. Now, this is how the Honorable Court addressed it. Your Lordship will see the discussion and reasonings, particularly from paragraph 8 onwards. So if I may place it, here the contention of the writ petitioner is that these imported cysts containing little organisms or embryos, which later became larvae, that prawn feed on. From this cystic stage, this little organism is nurtured and incubated till it grows and attains proper form and shape to be fed to prawns. Therefore, according to them, the nature and character of this product is not changed by nurturing or incubation. The product remains the same. The imported product was desired to be classified by the importer under heading 23, which includes products used as animal feed. Now, if the goods were classified under chapter 23, the assessee would have been entitled to a notification exemption benefit. So the classification was a precursor to that. According to them, prawn feed fitted the description. According to the customs, this product classifiable under chapter heading 0511.99, which refers to other products in the category of non-edible animal products. So this was a residuary category for which the exemption notification would not apply. The tribunal has passed this decision based on the decision with regard to importation of brine shrimp eggs of the Mumbai bench of the same tribunal in Commissioner of Customs Mumbai versus Atherton, reported in such and such. The tribunal has drawn further support from the order of the Supreme Court dated 4/4/2002, dismissing the civil appeal against the order of the Mumbai bench to the tribunal. The order of the Supreme Court as reproduced by the tribunal reads, "We have heard the learned counsel for the appellant. We find no merit in the appeal." It should be remembered that the above decision of the Supreme Court is the final decision on the particular consignment in issue between the parties involved in that litigation. So on the point of inter se disputes, this is my submission. I do not read that Supreme Court decision as an authority for the proposition that any product imported and declared as brine shrimp eggs would necessarily have to be classified in the other category under the heading 0511 for reasons given below. It is the categorical case of the writ petitioner that these goods which were imported by them were fertilized eggs. Now, why is this relevant? Because shrimp eggs can be fertilized and unfertilized. If it's unfertilized, it will never become prawn feed. If it is fertilized, only they will become prawn feed. So the argument was that fertilized eggs were imported, therefore they would develop into larvae and prawn feed. They contained embryos or little organisms enclosed within the cysts, which upon incubation in controlled temperature and hydration would become larvae, which could be used as prawn feed. It is submitted. If there is an embryo within the egg, then there is a living organism within it. Upon such incubation, the living organism merely grows. It does not change its nature and character. If there is no embryo within the eggs, then there is no living organism, and these eggs cannot be used as prawn feed. I am of the opinion that if an embryo is within an egg and it is subsequently incubated in controlled temperature and under hydration, the larvae which are subsequently born do not assume the character of any different product, but remain in the nature and characteristics the same product or organism which is within the egg. Therefore, if the eggs did contain an embryo, they could be classified as feeding materials for prawns and ought to have been so classified. These embryos may not be proper prawn feed at the time of importation, but could become so after incubation. Refusing to classify the product as prawn feed on this basis is not reasonable. In deducing the above principle, I have taken a lot of guidance from the case of Commissioner of Income Tax versus Venkateshwara Hatcheries, reported in 1999 Supreme Court. This was a 3-member larger bench decision of the Supreme Court. And it was about chicken eggs. I have the decision. I'll take your lordship to it subsequently. But it was there the assessee claimed that the incubation process was an artificial industrial process and they were entitled to certain deductions. The Honorable Apex Court was of the view that it's in the nature of an egg to hatch. It's a biological process. The incubation will only facilitate it or increase the hatching rate, but that in and of itself won't create something new. Now I come to paragraph 15. So, my lord, 14. Therefore, in the circumstances, there has to be a factual inquiry which has not been done. This is critical to this case. So the Honorable Court took the view that whether or not they're fertilized or unfertilized has to be determined on a consignment-specific basis. And to that extent, there has to be a factual inquiry in the case of each consignment. Thereafter, the general principles of classification may apply.
So according to you, the issue regarding classification has been put to rest
on the materials that were available at the time. Some elbow room was given to the department to carry out the factual inquiry and to show that the embryos existed and justify the change.
The onus is on the importer to show that the eggs were contained in embryo,
Yes.
which under controlled temperature can,
Develop into larvae.
Larvae, which will
Prawn
be a
feed.
prawn feed. So the principle is concluded. Factual examination was
That's
there.
right. That's all that was to be done. Now, Your Lordship will see paragraph 15. So we are talking about the finality and the bindingness of this order. Now, Your Lordship will see paragraph 15. I do not agree with the submissions of Mr. Chaudhary that the order of the Commissioner could not have been passed without assessment. In my opinion, such an order is in the nature of an assessment. But nevertheless, such order has been passed without making available the test report of the provisional assessment to the writ petitioner or by considering any material, whether from the seller's invoice or other materials available from the seller or elsewhere, regarding the exact nature of the goods. The pointed fact of inquiry should have been whether the imported goods contained an embryo of a live organism. This factual inquiry ought to have been made upon notice to the petitioner, and after giving them an opportunity to counter the evidence of the revenue and to produce his own evidence in support of this contention. So this was the number of steps that had been delineated, and at the top and at the very outset, this whole point on provisional and final assessment, this was held against the assessee. And that is the reason why I'm here today, because this decision was not entirely in favor of the assessee. There's a portion of it which is against. And to that end, the department holds the assessee bound. And that's why they proceeded with the Section 28 proceeding. And they opened up the interest demand for more than 20 years. Back before 2006, in provisional assessment cases, there was no interest demand. There was no provision in Section 18 calling for interest. But because of this judgment, there was a finality to that aspect. So how can the same judgment be binding to one extent, to the extent that it's adverse to the assessee, but to the extent that it's adverse to the department, not be bound? So in this regard, Your Lordship will kindly see what the adjudicating authority has held. And this is in volume, well, the order begins in volume 1, the first few pages, but it's actually volume 2. The main findings in volume 3. Stay petition. Volume 2. Now, Your Lordship will see page 122. The first few pages of the order are actually in volume 1, so I'm still not taking Your Lordship to that. So Your Lordship will see paragraph 2. This became the basis for the remand.
Yes.
Yes. Yes, madam.
They have expected the High Court order.
Yes, and it is that portion which I read out last on the provisional final assessment and then the steps that were to be taken in remand. They've quoted that in paragraph 2. Your Lordship will see page 133. In paragraph 6, they acknowledge that this is a de novo proceeding. And again, that paragraph is quoted in paragraph 6. Now, Your Lordship will kindly come to 138, page 138, where the discussions and findings are articulated. And the relevant portion is in paragraph, is in page 141, paragraph 10.3. Now, if I may place it, my lord, notwithstanding the fact that the sample drawn in respect of the present consignment has not been subjected to any test, the samples were drawn as a routine procedure and no test report was relied in the impugned show cause notice. The classification of the goods has already been decided by Mumbai Customs in case of identical import by the same importer. This is notwithstanding the distinction made by this honorable court. There was no dispute that the impugned goods were other than Artemia cysts, and therefore the testing of sample was not considered necessary. So even though this honorable court deemed it necessary, this the learned adjudicating authority didn't deem it so. The testing or non-testing of the samples would not have changed the basic nature of the goods, inasmuch as there is no dispute that the impugned goods are Artemia cysts. So fertilized, unfertilized, this is no longer an issue for the Honorable Authority. Once the correct description of the goods is acknowledged, then there is no discretion left with respect to its classification, inasmuch as the goods are correctly classifiable under Chapter 5. Similar dispute relating to classification of the same item of the said importer was decided by Sestat Mumbai. I'll take your lordship to that decision, and upheld by the Supreme Court, and the findings of my predecessor adjudicating authority upholds this viewpoint in unequivocal terms. Now, the gentleman goes on to confirm his order in page 142. Of particular note in the order is subclause D at the bottom of the page. I order for confiscation of the impugned goods covered under section 19. Now, I'll briefly deviate if I take your lordship to volume 3. So page 253, my lord. In volume 3, this is actually the ordered portion of the original adjudication orders, the very first order that was passed in the year of 2002. Page 253.
What is the date of the order?
2002, my lord. This is mentioned in page 239. Date is 25/11/2002.
No, it is 6/11/2000.
Or date of order 6/11.
Oh, I'm sorry, I apologize. 6/11/2002 on the top right-hand corner. That's right.
Against this, you came before the tribunal. Then,
That's right.
then the order of the tribunal is challenged in the writ petition.
Yes, the challenge in the writ petition set aside.
Set aside and matter
De
went
novo.
on. And the second adjudication order is
That's
volume 2.
That's right, my lord. I'm very grateful. Now, your lordship will see the order portion in page 253.
But this order has been set aside.
It's been set aside. But why is this relevant, my lord? It's relevant because there was no original confiscation of the goods.
Because by then provisional release was ordered.
Yes. So he says there's no confiscation. How did the remand authority confiscate the goods? In 2017, the order is being passed. If your lordship sees volume 2, in page 142, the portion that I showed your lordship, he's saying, I order for confiscation of the impugned goods, and he imposes a redemption fine of 75
he
lakhs.
says in page 253,
yes,
for such deliberate misdeclaration of the description, I confiscate the goods imported by the 19 bills of entry under 111M.
Yes,
the goods are not, however, available for confiscation since these have already been released provisionally.
That's right. If your lordship sees, there was no redemption fine of any sort imposed. And in fact, that was never an issue before the tribunal in the first round. That became an issue for the first time in the de novo adjudication. And this fact, and this is one of the questions before this honorable court, that the tribunal didn't even decide this issue. There's actually, in the 41-page order that's been passed in the impugned order, there's no exploration of this particular issue at all. Now, I'll take your lordship to the tribunal orders. One which was confirmed by the Supreme Court.
So, in the second order of adjudication order, confiscation has been ordered plus redemption.
Plus redemption fine of 75 lakhs.
Yes.
Now, Your Lordship will kindly return to the compilation which I had provided. Page 24 thereof. So this is the original split decision of the tribunal in the year of 2006. Page 24, Your Lordship will see paragraph 2 in particular, if I may place it. The dispute in the present case relates to the classification of brine shrimp eggs imported by the appellants. The import was made by the appellants prior to the impugned order of the commissioner, when the item in question, brine shrimp eggs, used to be classified under chapter heading 2309.90 of customs tariff heading as prawn feed. It was felt by the revenue that the item in question should be correctly classifiable under chapter customs tariff heading 0511, which attracts higher rate of duty. On parties' representation, the revenue permitted provisional clearance against a bank guarantee for the differential duty. So what one can glean from this, my lord, is historically, this is before the self-assessment regime was introduced in 2011. Historically, it is the department that used to classify under Chapter 23. Then when an exemption notification was introduced, they changed it for the consignment, first in Mumbai, and then for Kolkata, the provisional consignment, they wanted to classify it again under Chapter 5. This has been acknowledged by the tribunal, and it's also acknowledged by the Mumbai tribunal, as I will show later. Now, subsequently, when the High Court says that it is consignment specific, what I intend to submit before this honorable court is the department's actions, if we follow throughout the history of this case. They classified it as Chapter 23. They changed it for that particular set of consignments to Chapter 5. Then the High Court said that this consignment is going to be assessed separately or independently, should be seen that the factual inquiry is done reasonably. Chapter 23 may apply here. They accepted the finality of the decision and participated in the remand proceeding. So throughout the course of the history of this dispute or these consignments, the department has repeatedly shown that they wish to treat it as consignment specific and inter se the parties. So the classification was not meant to be recurring or a general broad-based principle having very wide and broad application. Rather, they intended themselves to make it consignment specific. And they finally agreed with the view of the Honorable Court. But then in a de novo adjudication, supposed to be concluded in 3 weeks, did it in 7 years, they applied the judgment to the extent that it says that Section 28 proceedings will continue, but they disagreed with that judgment in the remand proceeding. So the question before the tribunal was only this.
But how does the tribunal get over the...
Yes, Madam. Now I'll take your lordship to the tribunal decision. This is page 25, stay petition, volume 1. So this is the start of the order, page 25. And your lordship, so there are about 5 or 6 principles or points on the basis of which the finding has been arrived. The very first one, your lordship will see in page 48. Paragraph 11.2. 11.2, my lord. I will just place it, my lord. From the above arguments adduced by the appellants before the adjudicating authority, it is clear that they have been maintaining that the goods which were imported were prawn feed, classifiable under CTH 23. Nowhere in their reply or submissions had they taken a stand that the issue has to be decided by taking up the imported goods for testing towards the existence of larvae inside the eggs, and accordingly to classify the eggs with larvae under one heading and eggs without larvae under a different heading.
That was the direction in the...
That was the direction of the court, my lord. Now, if this honorable court has suo motu, in consideration of the Venkateshwara hatcheries case, has adverted to a certain line of thought, giving relevance to fertilization and unfertilization, is it that the assessee has to argue that? Is it that because this honorable court has broached a new line of thought, that a subordinate authority is no longer bound by a decision of the higher authority? that the tribunal has not adverted its mind to that line of reasoning. It has not considered the question of fertilization and non-fertilization. Therefore, we can choose not to be bound by the High Court's decision. Is that even a principle of law? So your lordship will see this in record in page 48. Then again in page 49, this is repeated. In paragraph 13.1 at the bottom. Again, it is repeated in page 56.
Which paragraph?
So in page 49, paragraph 13.1, the very last paragraph of that page. 13.1. Apparently, the appellants never took any stand. My lord, why did the Honorable Court consider the aspect of fertilization, non-fertilization? It was in the interest of both parties. It gave some elbow room to the department to justify its case also. So it was something that the court adverted its mind to.
Therefore, a test was deemed
necessary.
necessary. Then
so it was not dependent on what the assessee submitted. So just because an assessee did not make an argument before the tribunal of a similar sort, according to the tribunal, or the assessee never talked about larvae inside or larvae outside, that isn't a basis for saying that I'm not going to follow the High Court judgment. So again, this is repeated in page 58. Paragraph 16.1. And again in page 61. And again, so in page 61, your lordship will see in paragraph 18, right at the top. Finally, the matter was remanded to the adjudicating authority to follow the directions of the Honorable High Court while passing the adjudication order. The adjudicating authority, after following the principles of natural justice, this is the only line on natural justice in the entire order, has passed the impugned order, and being aggrieved, the appellants are before this tribunal. And why this is relevant, my lord, becomes apparent if your lordship comes to the bottom at paragraph 19.1. In paragraph 19.1, the Honorable Tribunal observes, as observed above, the adjudicating authority had very limited scope to fulfill this condition. So in 2017, they don't produce the test reports, they delay it, they make it very difficult for the assessee to supply evidence of its own accord to establish whatever conditions or the factual tests that the Honorable High Court had laid down. And the burden was cast or shifted onto the assessee to prove that the classification.
Problem is,
yes, my lord.
The remand itself was an ineffective remand. In the sense, the imported goods were not available.
They had taken samples, but they didn't test it. That is what the adjudicating authority. Samples were there.
For all 19 bills of entry.
Yes, they had taken consignments because they were provisionally assessed. All of them.
But then that should have been preserved in the
now who is responsible for that?
So therefore, if that is impossible of being complied with, then the classification issue has been put
decided. But that is what the assessee had said. Now, at the time, before the Honorable High Court,
they can't sit in judgment over the High Court order. Judicial discipline requires, see, the learned single bench interpreted the order passed by the Honorable Supreme Court, saying that it is consignment specific, it is not, your finality cannot be attached to it, gave its reasoning in 3 paragraphs, rejected his case that section 28 cannot be resorted to. After a provisional assessment, he rejected the case and sent it for a factual inquiry. So if you had preserved the samples, what the adjudicating authority should have done is, if they had the wherewithal, they had their own laboratory, they can do it, or refer it to an accredited lab to get the testing done whether it contains an embryo or not. Out of 19 bills, if suppose 2 don't contain the embryo, they are classifiable as under category others. Otherwise, it will be prawn feed.
I'll show, Milord, how they are prejudiced.
See,
Because,
it
Milord,
will be allergic to remand. We are not allergic to remand. Our trial court, our district judiciary is not allergic to remand. It's a learning process. It's a learning process. You accept it. So that's what Supreme Court says. Kamalakshi Finance, judicial discipline. And if the adjudicating authority wants to circumvent a finding, you could have done one thing. You accepted the judgment in the writ petition, and that portion of the judgment which went against him, you have utilized it and proceeded with the 28 proceedings. He couldn't question it because they didn't all file an appeal against the order passed by. So once you do and once you accept that portion of the judgment, the preceding paragraphs and the subsequent directions also is you are bound by it.
Milord, in brief, Milord, how the party is prejudiced because
such
Milord,
a lengthy order is not at all required.
Milord, the prime shrimp eggs that was never denied, Milord. Neither the party nor the department that it is a product is of brine shrimp eggs. Milord, now an attempt has been made to convert it to, it is presumed that it is a prawn feed. So on that contention, this test reporting and the requirement of the test report is being said. And on the aspect of test reporting, Milord, the prime shrimp eggs, if they have declared and admitted to it, does not, and then later on.
But the tribunal in the earlier round records
I will place
that all along you have been classifying it under chapter 23. The reason you switched over was because of an exemption notification. Until then, department never all its previous imports, and the only consignment which got caught subsequently after the exemption notification was the Mumbai import.
Milord, there has been brochures, Milord, where this processing has been.
No, can you go into it is the question.
No. Whether the knowledge they had is the question, Milord. Whether they had themselves had the knowledge.
First question, see, we cannot touch upon the classification. We are only on the question as to whether the tribunal and adjudicating authority understood the direction issued by the honorable in the writ petition in a proper manner. And the finding which has been rendered in paragraph 13 cuts the classification issue. So he has given a ruling saying that if the eggs did contain an embryo, they could be classified as feeding material for prawn and ought to have been so classified. It can't be more, it is typical Honorable Justice I.P. Mukherjee style. His English is very good. So therefore you can't sit in judgment. No? And in the first adjudication order, the authority says goods not available for confiscation. In the second round, how does he become wiser? And then no redemption fine was imposed earlier.
Yes, I'm out on Milord, that classification issue has been settled by the apex court.
Did it take the 7 or 10 years to decide?
Yeah, my lord, on the point of so many years, so first 98.
At whose instance the delay occurred?
So the delay occurred at least. So this is difficult for me to say because two directors have passed away. The concerned advocate has passed away. So this case meandered to me sometime in the year of 24. And in this regard, your lordship will see volume 2. I have made a specific submission to this effect before the tribunal. Volume 2, lordship will see. In page 206. Volume 2, stay petition. Page 206.
These are grounds, is it?
Yes, my lord. And your lordship will see paragraph 3.1. I will place it, my lord. Though the High Court in its judgment observed in paragraph 14 thereof that there has to be a factual inquiry which has not been done. And
sorry, page?
Oh, page 206, my lord.
206 is it?
206 of volume 2 of the state petition. paragraph 3.1.
No, yes.
So if your lordship sees, there were basically 2 points which were pressed by me. One was judicial discipline, second was inordinate delay of 7 years. So why was it relevant in this case? Because usually in a remand proceeding, even if there's a delay, ordinarily, even if there's a 7-year delay, courts are not willing to set aside the case, as they do in the case of show causes. But here, what happened? Though the High Court in its judgment observed in paragraph 14, there has to be a factual inquiry which has not been done, and mandated in paragraphs 15 and 16 that the appellant be given a chance to counter such factual evidence and re-decide the disputed issue subject to its observations. The learned commissioner delayed the de novo. I made a factual submission in this regard. Delayed the de novo adjudication by a period of around 7 years. During this time, the director of the appellant passed away. I attached the death certificate. If your lordship sees the adjudication order, penalty was imposed on the deceased individual and was succeeded by persons including his now widowed daughter-in-law that were not familiar with the disputed transactions. The other director had resigned from the appellant company on January 2002, owing to internecine disputes, making it difficult for the appellant to properly defend its case with fact and evidentiary materials after the lapse of so many years. Copy of Form 32 attached. The appellant company had also stopped imports of prawn feed ever since the initiation of the subject dispute and no longer retains technical information specific to the trade of prawn feed. The appellant has also only come to learn in 2017, following the passing of the impugned order, that no test reports were ever prepared by the department during the pendency of the subject dispute and cannot, after the lapse of so much time, unilaterally provide any additional consignment-specific evidence at this stage to justify the classification of the said goods in the manner declared by it. And the relevant reference was drawn to the ATA freight line case of the Supreme Court, which is mentioned in page 209. It's annexed in page 209. Your lordship will find there's only one observation in the tribunal order, that the adjudicating authority complied with principles of natural justice. That's the only finding.
In the adjudication order,
yes,
normally in the first paragraph, they start by saying why it is taken up now, etc. Is there any reference? Volume 1, it should be.
Mano, this is the second adjudication, the de novo adjudication. So page 122.
No, and the preamble normally.
Oh, the preamble is in page, in volume 1, page 119.
No, volume 2.
Oh, volume 2, page 122. So it carries on. So page 122, paragraph 1, your lordship will see direction issued by the Honorable High Court. And then again in page 133. For your lordship's convenience, I've prepared an index to help your lordship navigate the field.
But they don't say why they sat tight for 7 years.
No, they don't say that. There's no explanation in the order as to why they didn't.
I can recollect from the brief, they, by writing letters of time stating that it is a sub judice matter, so unless and until it reaches finality before the apex court, they should hold it.
No,
I recollect from, but I will produce,
let
I
that be produced,
absolutely
because as I understand it, my lord, this honorable court decided.
My lord, I absolutely recollect, but which volume, my lord, I'm trying to find out.
No.
But I recollect.
What was pending before the apex court?
There was nothing pending.
Because the classification issue was pending.
My lord,
many consignments. This is not a third.
No, it was not. See, when the writ petition was disposed.
My lord, I got it, my lord. Page 1 to 4, my lord. If I may place 3.4 of volume, my lord, mine is volume 2. Mrs. Atherton Engineering, vide their letter dated 14th January 2002, informed DRI that the issue of classification of brine shrimp eggs, Artemiasis, prawn feed is sub judice before the Honorable Supreme Court. It appeared from the document submitted along with the said letter dated 14th January 2002 that the case which was sub judice before the Honorable Supreme Court of India relates to show cause notice issued under Section 28 of Customs Act wide F number this dated 18th of August 1998 by New Customs House Mumbai for import and duty-free clearance of 5 consignment of brine shrimp eggs, Artemiasis, prawn feeds, wrongly claiming assessment under Customs Tariff Heading 2309.90 in the year 1998 through Mumbai. It is also that the case was admitted by the Apex Courts. Thus, DRI found that there is no bar imposed for initiation of any.
This is the narration to the show cause.
See,
in 2000.
the special petition was dismissed on 4th of April 2002. So, nothing was pending when there is a direction to conduct de novo adjudication. The court has taken note of the dismissal of the SLP, rendered a finding as to how that judgment will not affect this import.
Malo, this was when they were provisionally assessing the book. So this is the narration to the 2002 show cause notice.
But
See,
that is when the Supreme Court
matters.
DRI issued the show cause, answerable to the jurisdictional commissioner. When the DRI issued show cause, appeal was admittedly pending. So therefore, they gave a letter on 14th of January, please wait. But ultimately, the SLP was dismissed on 4th of April 2002. Then all things happened.
All these proceedings were done.
So therefore, you cannot say that adjudication took 7 years, de novo took 7 years because SLP was pending. Nothing was pending.
But matter was before High Court thereafter. Then they went
not between 2010 to 17, my lord.
No. 2010 is the order passed by the writ court.
But then there was a de novo direction, my lord. Order of de novo proceedings, my lord.
That is in 2010, madam.
Yes, after that. My lord, kindly, what I have is that I have. My lord, may I place page 133 in this regard?
No, forget about that delay. Now, how will you get over the finding rendered in WP? What is that number?
My lord,
that is the judgment in page 16. 203 of 2017.
Honorable,
ELT 358.
So that, my lord.
Page 16.
It's 16. That, my lord.
Compilation.
That, what I
page
can
16.
have. Yes, page 16 of Honorable Justice.
The compilation. Oh, yes.
Judgment. Well, may I please, Lord, the de novo adjudication, Lord, in this regard? But I'll just place the relevant portions which I find relevant for this case and after this argument. So factually, my lord, the impugned de novo proceedings in pursuant to Honorable High Court's Calcutta order dated 13th of April 2017 in WP 203 of 2017 in the matter of Atherton Engineering Company arising out of SESTAT final order number A 294 to 296 dated 2nd of March 2006, wherein compliance of the earlier order dated 10th March 2010 in the WPO number 748 of 2006 has been directed. The Honorable High Court's order dated 13th April 2017 order in WP 2003-2017 has directed inter alia that this for de novo adjudication.
Where is that order? 13/4/2017 order.
13/4/2017. Yes, my lord. This is
many compilations.
It's not there in the company.
No, it will be there, my lord. It's there.
So you filed a writ petition because the de novo adjudication was not done.
Yes.
So you filed a second writ petition.
Yes, that the de novo adjudication, that order is there. So Justice Boshak had directed that this be concluded immediately.
Justice Boshak's page 154.
154, my lord. Volume 2, page 154.
Same volume.
Volume 2, page 154.
13
So this is the order. This is the 2017 order.
Volume 2,
Page 154, my lord.
of the same compilation, Lord.
But this is WP 203 of 2017.
Yes.
That's my number. That's
second,
What is the 17?
203 by 2017.
May I place it? The petitioner complains that despite the judgment and order dated March 10, 2010, passed in WP 748 of 2006, Atherton Engineering Company Private Limited versus Union of India and others, directing the Commissioner of Customs, Airport and Administration to redecide the matter in accordance with the observations made therein. Within a period of 12 weeks from the date of communication of such order, the authorities has not done so. The learned advocate for the petitioner submits that subsequent to the judgment and order dated March 10, 2010, the petitioner has appeared before the concerned authority and was heard. The petitioner has submitted written notes of arguments. The learned advocate appearing for the department submits that the department has labored under impression that an appeal was carried against judgment and order dated March 10, 2010. Therefore, the proceeding was not disposed of finally. Since the department has now come to learn that there is no appeal against the judgment and order dated March 10, 2010, passed in WP number 748 of 2006, the appropriate authority will take expeditious steps in deciding the issue. I have considered the rival contentions and the materials on record. The petitioner had filed an earlier writ petition being number WP 748 of 2006, Atherton Engineering Company Private Limited versus Union of India, challenging a final order dated March 2nd, 2006, passed by the Customs, Excise and Service Tax Appellate Tribunal EZB. Such order was set aside by the judgment and order dated March 10, 2010. By directing the Commissioner of Customs, Airport and Administration to rehear and redecide the matter in accordance with the observations made therein, although a hearing took place, final order has not been passed. It is likely that the person who had heard the petitioner is no longer in the post. The petitioner, pursuant to the order dated March 10, 2010, may not be in the office any longer. The person presently at the post specified by the order dated March 10, 2010 is at liberty to proceed with the hearing of the matter as directed by the judgment and order dated March 10, 2010, either afresh or from the stage up to which it has reached. In order to facilitate the commencement of the hearing, it would be appropriate to fix a date and time for the parties to appear before the designated person. The learned advocates for the parties suggest that the proceedings may commence on and from April 26, 2017. The parties will act in terms of judgment and order dated March 10, 2010, passed in WP number 748 of 2006. In deciding the issues as directed therein, the time period specified in such order will commence from April 26, 2017.
So the stand of the department was, they thought an appeal was filed.
And there has been a...
So therefore, the delay is only attributable.
And the post was lying back in Millard, in addition.
Even before 7 years, my lord.
And then
I
thereafter...
joined practice during that time.
Then you
Till
can't
thereafter.
get over the finding recorded in the order passed to the disposition. And the remand was to decide the matter in accordance with the observation. So it was not an open remand. You cannot reopen a settled issue. All that you can do is, if you have had the representative samples drawn, you may put it to a test report. He was entitled to bring in evidence to show that it is classifiable under chapter 23 and not under chapter 5, under the category others. So that exercise was not done. They misunderstood the scope of the order, picked up only one paragraph which is in favor of the department and proceeded to do it.
But the
Tribunal on its part also wrote 40 pages judgment.
No.
I don't know what is.
Milord, I beg to differ, Milord, but the classification issue was decided by the Honorable Apex Court, Milord. Although this observation...
That we will give reasons how it was not decided. See, you always say every assessment here is different. Every consignment you import is different. So this change of thought process only was because of the exemption notification or concession or exempt, totally exempt.
No, there was a concessional rate.
Concession.
concession.
And whether
See, the same with the edible palm oil also, same issue. Until then, you are arguing your reserve judgment, whether the bill of entry can be substituted after having, and you argued elaborate notes you have given. We are also doing some research.
Milord, may I then
And
place?
fellows have
Milord,
gone out of business.
Kindly let me
People have
place,
died.
Milord, the relevant portions of the de novo adjudication.
That is the thing by that years after. Years after.
Milord, that part has been observed.
Yes.
Milord, may I please, Milord? Finally.
What the hell? Mukherjee in his order. Still, remember the whole issue of Supreme Court is on the particular consignment issue. Do not read the judgment is a party for a proposition. The absolute sort of important declared as blind would necessarily have to be classified other categories under heading 05 for the reasons given. Yes.
Milord, with respect to the notification issue, directly and briefly, Milord, may I please page 131, Milord? Milord, the question is whether they have obtained the order informing the subsequent notification. Milord, this has been stated, Milord. Thereafter, I will go to the rest part, Milord. 5.3, page 131 of the volume 2.
Into
131 page. 5.3. Therefore, the matter was placed before the third member taking into consideration the records, orders of the learned member, and hearing both the parties observed that since customs notification number 163/94 cast dated 02/09/94 has been rescinded, superseded by notification number 47/96 cast dated 23rd July 96, and the period involved is from October 1998 to February 2001, and held that matter should not be remanded to the Commissioner for de novo adjudication as held by the learned member judicial. Further, he observed that the matter was put up to him for limited purpose, whether the duty is required to be confirmed against the appellants and the penalty reduced as held by the member technical, or the matter is required to be remanded to the Commissioner as held by learned member judicial. So he was not inclined to give any opinion on the question of penalty and directed that the matter took place before Honorable President Estate, New Delhi, Mrs. Archana Wadhwa, member judicial, in view of third member's opinion, observed that in paragraph 19 of the order recorded by her, the matter was also remanded for deciding upon the imposition of the personal penalties upon, alternatively, in the light of the observation made in the preceding paragraph in para 18. Learned third member has concluded that the matter has not been referred to him on the point of penalty. However, she felt that the above observation is not correct, in as much remand order included remand on penalty point also, in which case learned third member was required to resolve the difference on this point, that is remand to decide on the imposition of penalties. Thus, Sestat by this order dated 5th September ordered that in view of majority order, the demand of duty is confirmed and the penalty on Atherton Engineering is reduced to 25 lakhs, and the penalties on Vikram Jaitwa and RB Jaitwa is reduced to 2 lakhs each. Now, my lord, this is clear that all the arguments that has been made not mentioning about the customs notification which was existent at the relevant time for that relevant period, my lord. And this order was obtained.
No,
My lord,
how are all these relevant now?
I'll explain, my lord, what happened. My lord, what happened is,
Exemption issue that was pointed
my
out.
lord,
that-
no, that not at all. So what happened was in the 2:1, the split decision. So there was a classification case under chapter 23, chapter 5. So there was an alternative plea that was taken by the appellant's counsel that perhaps the 96 notification should also be looked into. This is not to do with chapter 23. Chapter 23 notification is different. Once I come to chapter 23, automatically this notification will apply. The department's cases, I don't come under chapter 20. So naturally, I will not get the benefit. This is the notification. This is a 99 notification, not a 96 notification. This is the. So if your lordship sees page 20, item serial number 20. Serial number 20 in the second page.
From feed 2309.
Yes. This is the notification. So this 98 to 2000 is the period under consideration. So what had happened is the assessee had taken a reserve argument in case it lost on the chapter 23, chapter 5 classification. And the judicial member said, well, if even on the point of classification, if it is decided against the assessee, the adjudicating authority should have dedicated some time to exploring whether this 96 notification applies. The matter was referred to the third member. And when the matter was referred to the third member, it was brought to the attention of the third member that that 96 notification has been rescinded. So by a 2:1 judgment, the tribunal held against the assessee, saying goods are classified under chapter 5, not chapter 23. This was the case.
So the contention of the notification was brought into before the tribunal only.
No, all that gets effaced after the order which was passed in the writ petition.
That is.
So the matter has been so all that the adjudicating authority what was required to do is to scrupulously follow the direction. He followed it, which was in favor of the department, and proceeded with the 28 show cause notice. But what about the other observations? He sat in judgment over the order passed by this court. The same mistake has been committed by the tribunal. Indiscipline.
But I'll then rely to replace again the Honorable Justice Aitam Mukherjee's.
So we need not go that far. We need to see from the stage when the matter was sent back for de novo, what was there. The first issue is why was there delay? And the matter started moving only after he filed a writ petition in the year 2017, where the court fixed a time limit. Your submission before the court was, we were under the impression, as against the 2010 order, an appeal was preferred. Then it dawned upon us that we didn't file an appeal. So therefore, you agreed for a date. Matter started.
Then from the de novo, I'll place the relevant portions where it is clear.
See, the entire order has been devoted with regard to the classification issue. The simple question is whether at all if we cannot decide a classification issue, but then even assuming your argument is it is not inter-party, it will affect the other imports as well. So a general principle of law has to be laid down. Matter can go to the Supreme Court. We need not travel that far. That is why there are substantial questions which they have raised doesn't touch upon classification.
Substantial questions,
The supplementary affidavit.
Yes.
You please see.
Yes, I have.
First is judicial discipline. Second is not adhering to the direction in the writ petition.
Yes.
Question number 2. Third is also relating to that. Fourth is principles of natural justice. Fifth is delay. Sixth is also relating to the binding effect of the order in the writ petition. Then 11, 12 is on whether on de novo adjudication, whether he could have directed confiscation and imposed redemption fine. Fifteen is trust report. 17.
Yes, ma'am. 17.
Portion of the order you have accepted, the remaining portion you don't want to accept.
And paragraph 4, page 7 is my submission for maintainable.
Paragraph
4 of page 7.
Correct. And this decision concerns the subject consignment. So it is binding. Once it has attained finality, all that in the de novo adjudication was to carry out the direction given in the last two paragraphs. That's nothing more than.
But if then by that time Supreme Court has already decided the issue under the
No.
classification.
No, that the Supreme Court dismissed that special petition in 2002.
Yes, sir. But that decision
Correct, Steve.
under the classification.
Please accept. The learned judge has discussed this issue in paragraph 10 of his judgment,
Yes.
page 18 of the compilation. And in paragraph 11, he says that it is consignment specific. It will not bind. And then proceeds to give reasons why it has to be classified in this manner. And all that you are required to do is whether the imported good contains an embryo or a living organism. That alone you need to do. For which purpose you need to conduct a test, put the test report to him, allow him to produce counter evidence, counter that particular evidence by producing his own evidence. That's it.
The words that is written over here and that has been understood, rehear and re-decide. The relevant parties, as well as the order.
Decide the matter.
Rehear and re-decide the matter. Yes, in accordance with the above observation within a period of 12 weeks from the communication of this order.
All right. Please come. This appeal filed by the assessee or by the importer is directed against the order dated 26/6/2024, passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, within bracket Tribunal, by which the appeal filed by the appellant herein, challenging the de novo adjudication order in order in original dated 12/9/2017 was dismissed. The appellant has raised the following substantial questions of law for consideration. There is some repetition also, no? In your
Yes, my lord. There's a quotation of all the tribunal orders which were set aside. There's about 30 pages of quotations.
No.
In
your substantial questions.
Oh, my lord.
Some overlapping is there.
I understand.
So we will have question number 1.
So I'll yes, my lord.
Question number 2. Binding nature, question number 3.
My lord, 5, 12 and 17.
5, 12, 17.
This more or less covers.
You have heard so also. The case on hand has had a checkered history, and it may not be necessary for us to recapitulate all the earlier facts as to how the adjudication proceedings were done, how the matter was carried to the learned tribunal, where the learned members rendered differing opinion, reference to the third member, and the orders passed in a writ petition, etc. This is so in the light of the fact that earlier the petitioner had approached this court and filed a writ petition in WP number 748 of 2006, challenging the order passed by the tribunal dated 2/3/2006, which decision is reported in 2007 208 ELT 464 within bracket TRA - Kolkata bracket close. This final order passed by the learned tribunal is by a majority of 2:1. Before we examine the matter on merits, and test the correctness of the findings recorded by the learned tribunal, we propose to answer the question as to whether this appeal could be maintainable before this court and whether the issue involved touches upon classification of goods. In fact, this question was posed by the court to the learned advocate appearing for the appellant, though not raised by the department in such form and manner. To answer this question, we may straightaway refer to few decisions of the Honorable Supreme Court which have decided as to when and under what circumstances an appeal would be maintainable before the Honorable Supreme Court and when it would be maintainable before this court in terms of Section 130 of the Customs Act 1962. The Honorable Supreme Court in Commissioner of Customs Bangalore 1 versus Motorola India Limited 2019 368 ELT 3 within bracket SC referred to an earlier decision in the case of Naveen Chemicals Manufacturing and Trading Company Limited versus Collector of Customs 1993 4 SCC 320. Sir, this is page 14 of the compilation. And held that a dispute that where the value of goods for the purpose of assessment is required to be increased or decreased is a question that relates directly and proximately to the value of goods for purposes of assessment. Full stop. The statutory definition of the said expression indicates that it has to be read to limit its application to cases where, for the purpose of assessment, the question arises directly and proximately as to the rate of duty or the value of the goods. Noting the above observations, above finding rendered by the Honorable Supreme Court in Naveen Chemicals, the Honorable Supreme Court held that when an order of the appellate tribunal would go beyond inter-se disputes, disputes between the parties and may affect a large number of cases, such an issue will be one of general public importance. It has been further held that in certain questions raised or arising may require interpretation of the Constitution. Once such questions of general importance alone are required to be decided by the Honorable Supreme Court, and the very nature of a question raised or arising, please take your seat. Arising, the same necessarily has to involve issue of law going beyond the parties, PARTES, rights and extending to a class or category of associates as a whole. On the facts of the said case, within bracket Motorola, the Honorable Supreme Court observed that the only question is as to whether the assessee therein has breached the condition which are imposed by the notification for getting exemption from the payment of customs duty or not. And the appeals do not involve any question of law of general public importance which would be applicable to a class or category of assessees as a whole. and the question is purely inter-se between parties and is required to be adjudicated upon the facts available, and therefore held that the High Court was not justified in holding that the appeals are not maintainable under Section 130 of the Act. The decision in Motorola was followed by the Honorable Supreme Court in Commission of Central Excise, Customs and Service Tax, Mysore versus Such Silk International Limited, 2022, 1 Syntax 18 within bracket SC, in Asian Cable Ship PTE Limited versus Commission of Customs, 2022 380 ELT 4 within bracket SC, and Commissioner of Central Excise Hyderabad, Hyderabad versus Sriram Refrigeration Industries, 2022 382 ELT 20 within bracket SC. In the preceding paragraphs, we have quoted the substantial questions of law which are required to be decided in this appeal, and on a bare perusal of the same, it will be evidently clear the matter concerns dispute inter parties, and it is not a case which involves not the case where the court has to decide the value of the goods for the purpose of assessment, or a question which relates directly and proximately to the value of the goods, and not a case where the issue of law would go beyond the inter-se parties and extend to a class or category of assessees as a whole. In the light of the above, we hold this appeal is maintainable before this court. Reverting back to the factual position in the instant case, as observed earlier, it would suffice to note the facts which have arisen after the order passed in WP 748 of 2006 dated 10/3/2010 within bracket 2010 256 ELT 358 within bracket Calcutta. In the said writ petition, the appellant challenged the order passed by the learned tribunal dated 2nd March 2006, which was a final order passed by a majority of 2:1. The appellant is an importer, and during October 1998 to February 2001, it imported several consignments of a product called Artemia, ARTMIA cyst, within bracket brine shrimp eggs. It is there in paragraph 17, para 3. The appellant described and declared this product as prawn feed within inverted comma. And on this basis, the goods were assessed by the customs provisionally by accepting bank guarantee as security for the duty that may be finally assessed. Full stop. If the goods were classified by the customs as prawn feed, inverted comma, there was a duty exemption before 1999 budget and only 5% basic duty after that. The Directorate of Revenue Intelligence intervened during 1999 and stated that the goods were not prawn feed and they had to be classified differently, attracting a higher rate of duty. If the goods are classified as prawn feed, inverted comma, the appropriate head under which it will be classified is Customs Tariff Heading 2309.90 under the Customs Tariff Act, 1975. According to the customs authorities, it would fall under chapter heading 0511.99, and that the imported goods were not prawn feed. Further, the department was of the view that the cysts, CYSTS, had to be incubated in controlled temperature and oxygen and hydrated in hatcheries. And after this incubation period, one would get an organism known as NOPLI, NAUPLII, which is food for prawn. And according to them, these imported goods have to undergo some process to become prawn feed, and therefore there was a misdeclaration of goods, and the appellant would have to face its consequences. The appellant challenged the order passed by the tribunal by contending that the provisional assessment was made on or about 15th April 1999, but no final assessment was ever made. Semicolon. The show cause notice was issued on the basis of provisional assessment. Semicolon. The show cause notice was adjudicated on the basis of evidence at the time of provisional assessment. Semicolon. The product imported were eggs with a live organism or embryo. Full stop. This live organism or embryo, upon nurturing and incubation, became prawn feed. Full stop. It was always prawn feed, comma, at its infant stage, and the product after nurturing and incubation was not something different from the product imported. And test reports during provisional assessment are not made available, and the appellant did not have adequate opportunity to substantiate the contention that the imported goods were eggs with a live organism or embryo, and after nurturing and incubation, they became prawn feed, and there was no change of the nature of the product imported. The appellant placed reliance on the decision of the Honorable Supreme Court in Commission of Income Tax versus Venkateswara Hatcheries Private Limited, 1999, 237 ITR 174, where the assessee was in the business of hatchery, and the Honorable Supreme Court held that the assessee did not contribute to the formation of chicks, and the formation of chicks was a natural and biological process over which the assessee had no hand or control, and the assessee was helping the natural and biological process of giving birth to chicks, and the birth of chicks was an event of nature. Event of nature did not come. This I have taken from page 17. Reliance was also placed on the decision of the Honorable Supreme Court in Commission of Central Excise and Customs, Mumbai versus ITC Limited, 2006-203 LT 532 within bracket SC, to support their contention that the alleged short payment of duty can arise only upon completion of assessment, as it was the case of the appellant that no final assessment was ever made. The Honorable Court took into consideration the Honorable Court, while considering the correctness of the finding rendered by the learned tribunal, took note of the fact that the decision of the learned tribunal was based on a decision with regard to importation of brine shrimp eggs of the Mumbai bench of the tribunal in Commissioner of Customs within bracket P preventive, Mumbai versus Athiron Engineering Private Limited, 2001 129 ELT 502 within bracket TRI, MUM, bracket close. And wherein the tribunal accepted the classification made by the department under chapter heading 0511.99. This decision of the Mumbai tribunal, Mumbai bench of the tribunal, was upheld by the strike out there. The revenue challenged the said order the appellant challenged the said order before the Honorable Supreme Court, and the special petition was dismissed on 4/4/2002. The Honorable Court first examined as to the effect of the decision of the Mumbai tribunal, and held that the decision of the Honorable Supreme Court is the final decision on the particular consignment in issue between the parties involved in that litigation, and the decision of the Honorable Supreme Court cannot be read as an authority for the proposition that any product imported and declared as brine shrimp eggs would necessarily have to be classified in the inverted comma other category inverted comma close under heading 0511. In the following reasons were given by the Honorable Court to support the above conclusion, and it will be beneficial to extract the relevant paragraphs of the said order. Page 18, paragraph 11, 12, 13. Thus, in the above order, the classification issue has been put to rest, wherein the court held if the eggs did contain an embryo, they could be classified as feeding material for prawns and ought to have been so classified. The embryos may not be proper prawn feed at the time of importation, but could become so, after incubation. And refusing to classify the product as prawn feed on the basis is not reasonable. In this regard, the decision of the Honorable Supreme Court in Venkateswara Hatcheries was referred to. The above findings rendered by the Honorable Court has attained finality, and the revenue has not preferred any appeal. After having held so, with regard to the classification, that the product has to be classified as prawn free, the court thought fit to remand the matter for an inquiry, factual inquiry, to examine as to whether the goods, imported goods, contained an embryo or a live organism, and that this factual inquiry ought to have been made upon notice to the appellant/writ petitioner, and after giving them an opportunity to counter the evidence of the revenue and to produce his own evidence in support of his contention. With the above finding, the following directions were issued. Please quote same order, page 18, paragraph 14 to 16. In paragraph 15 above, the argument made on behalf of the appellant that proceedings cannot be initiated under section 28 of the Customs Act without there being a final assessment was rejected, as against which the appellant had not carried the matter on appeal, and such finding also attained finality. Thus, the scope of the remand has been clearly circumscribed by the court, and in the de novo proceedings, the authority has to scrupulously follow the directions issued by the court and cannot deviate from the same. Unfortunately, the authorities lost sight of the effect of the direction, and in the de novo adjudication, reopened the entire matter and proceeded to render a finding against the appellant. The Honorable Supreme Court in Union of India versus Kamalakshi Finance Corporation Limited, 1991, 55 ELT 433 within bracket SC, page 43 of the compilation. The Honorable Supreme Court held the principles of judicial discipline require that the orders of the higher appellate authority should be followed unreservedly by the subordinate authorities. The mere fact that the order of the appellate authority is not acceptable to the department in itself an objectionable phrase and is the subject matter of an appeal can furnish no ground for not following it unless its operation has been suspended by a competent court. Further, it was held that if this healthy rule is not followed, the result will only be undue harassment to assessee and chaos in the administration of tax laws. This decision has to be borne in mind in the instant case, as we are of the clear view that the adjudicating authority, while commencing the de novo adjudication process and culminating the same by an order dated 12/9/2017, virtually sat in judgment over the direction issued by this court in the decision reported in 2010 256 ELT 358 within bracket Calcutta. Not stopping with that, the adjudicating authority proceeded to order confiscation of the goods and also imposed redemption fine. This was clearly without jurisdiction, as in the first round an order of adjudication was passed. Order of adjudication was passed dated 6/11/2002, wherein the adjudicating authority in no uncertain terms holds that the goods are not available for confiscation since they have already been released provisionally at the request of the importer, and no redemption fine was imposed. If that be the factual position, on a de novo adjudication, the authority exceeded its jurisdiction in ordering confiscation of the goods which admittedly was not available and also ordering for redemption fine. One more major error committed by the adjudicating authority is to impose penalty on one of the directors of the appellant who was no more. This aspect has been specifically pleaded by the appellant before the authorities. Though several grounds were raised by the appellant before the learned tribunal, the learned tribunal lost sight of the scope of the remand pursuant to the order passed by this court, despite the fact it has noted the order passed by this court in paragraph 11.2 of the impugned order. However, the appellant was non-suited on the ground that they never took any stand that the eggs with larvae would be classified under a particular heading and the eggs without larvae would be classified under a different heading and different heading. This observation made by the learned tribunal in paragraph 13.1 and other paragraphs are wholly are not sustainable, as it tantamounts to sitting in judgment over the order passed by this court in the writ petition filed by the appellant. When the department had not carried the matter on appeal, the question of it is incumbent upon the department to accept the judgment and all the directions contained therein in full. Rather, the department was selective in accepting a portion of the judgment which was decided in favor of the department and against the appellant. This is also this would clearly show that the order of de novo adjudication was thoroughly flawed, and this aspect of the matter has been lost sight of by the learned tribunal while passing the impugned order, which would render the impugned order perverse in law. Perverse. One more aspect which requires to be highlighted which is evident one more aspect which has to be noted is the inordinate delay in commencing and completing the de novo proceedings. The writ petition filed by the appellant was allowed, and the order passed by the tribunal was allowed on 10/3/2010, and the order passed by the tribunal dated 2/3/2006, as well as the order of the commissioner dated 6/11/2002 were set aside. And the Commissioner of Customs within bracket Airport and Administration was directed to rehear and redecide the matter in accordance with the observation within a period of 12 weeks from the communication of the order. This direction has not been complied with by the department, and it has taken 7 long years for the department to commence the de novo adjudication. That too, after a direction was issued in a writ petition filed by the appellant in WP 203 of 2017, dated 13th April 2017. The delay is attributable to the department, and the department is solely responsible for the delay, as is evident from the submissions made before the learned writ court in WP 203 of 2017, to the effect that they were under the impression that an appeal was filed against the order passed by in the writ petition dated 10/3/2010, when the fact remains no such appeal was preferred. Therefore, this delay has resulted in great prejudice to the appellant, which cannot be compensated. Which is the decision you showed for delay?
That is in.
You gave it separately.
Yes, my lord. This is, your lordship will see volume 2. Page 209.
In this regard, we take note of the decision of the Honorable Supreme Court in Union of India versus ATA Freight Line India Private Limited to 2023 6 syntax 153 within bracket AC, wherein the Honorable Supreme Court dismissed the appeal filed by the Union of India against the decision of the High Court of Bombay in ATA Freight Line India Private Limited versus Union of India 2022 1 syntax 32 within bracket Bombay 32 within bracket Bombay, wherein the Honorable Division Bench of the High Court of Bombay held that the department cannot adjudicate notices that were transferred to call book without communicating the same to the SSC for 7 to 11 years. And the department was under a duty to take notice issued to its conclusion by adjudicating the same within reasonable time. The case on hand is better on facts, as there was a time-bound direction given by the learned writ court while allowing the writ petition filed by the appellant. So this is also one more ground to set aside the adjudication order and de novo adjudication order, as well as the order passed by the learned tribunal. Yet another very important issue which comes to light from the order passed by the tribunal reported in 2006 197 ELT 428 within bracket Tribunal Kolkata. It is on page 24 of the compilation. Is that all along the department had been classifying brine shrimp eggs under heading number 2309.90 of the customs tariff heading as prawn feed. And it is only after a notification was issued by the government reducing the rate of duty, a sudden change of stance has been taken by the department. This is also one more fact which should inure in favor of the appellant. Thus, for all the above reasons, we are of the clear view that the adjudicating authority, while carrying out the de novo proceedings, clearly exceeded this jurisdiction and proceeded to reopen a settled issue which could not have been done, and this aspect of the matter has not been taken note of by the learned tribunal in a proper sense, which results in perversity in the order passed by the learned tribunal. For the above reasons, the appeal is allowed and the order passed by the learned tribunal as well as the de novo adjudication order are set aside, and the substantial questions of law are answered in favor of the appellant. Now what to do? Now de novo adjudication order was 7 years. Matter traveled to tribunal. Then we have come here. Now close to about 15 years have lapsed.
Yes, my lord.
It is a fait accompli to send the matter back. Even assuming you have got some test tube samples, you don't have the facility in your customs barrier area to preserve it in an appropriate condition. So, therefore, what we will say is, in the light of these circumstances, the classification as adopted by the appellant should be accepted, and the benefit of the notification should be extended. And in this regard, the adjudicating authority shall pass an order complying with this. That is the only thing. Otherwise, those fellows also will struggle. What he can do? First, to locate that sample. Where is that sample?
But the sample probably won't even survive.
Pardon, sir?
The sample won't even survive.
Don't survive. Don't survive. In the preceding paragraphs, we have noted the gross delay which had occurred in the entire process. The import was during the period 1999 2000.
1998 to 2000.
No, the import this import was also through Mumbai port. The import of the consignments covered under 19 bills of entry was effected in August 1998. The
P3, volume 3, 230.
The show cause notice, what was the date on which DRA issued show cause? You take page
23rd January 2002. Milord.
Pardon?
23rd January 2002, page 183.
23rd January
2002
by DRA.
by the DRA.
The show cause notice was issued by DRA on 23/1/2002. And roughly about the same time, the goods were permitted to be provisionally cleared, subject to furnishing bank guarantee. The appellant submitted reply to the show cause notice, which was answerable to the jurisdictional commissioner, namely the Commissioner of Customs, Calcutta, not Kolkata, at that time Calcutta, who took up the same for adjudication, and an order of adjudication was passed on 6/11/2002. Correct?
Yes, ma'am.
The appellant carried the matter on appeal to the learned tribunal. The learned tribunal delivered a split verdict. Which necessitated the matter to be referred to a third member. And by a majority decision, the learned tribunal held against the appellant by order dated to 2/3/2006. Correct?
That's the yes, Manu. That's the third.
This order was put to challenge by filing WP number 748 of 2006, which was pending and finally allowed on 10/3/2010. No appeal was preferred against the said order. I'll finish one paragraph. The de novo adjudication did not commence within the time permitted by the High Court, but commenced after a period of 7 years. That too, after a direction was issued by this court in a writ petition filed by the petitioner in WP 203 of 2017, dated 13th April 2017. The de novo adjudication was commenced and completed, and an order was passed on
12th September 2017.
12th of September 2017.
2017.
12/9/2017. Against this order, the appellant preferred appeal before the learned tribunal, and the learned tribunal dismissed the appeal filed by the appellant by order dated
26 June 2024.
26 June 2024, against which this appeal was filed before this court. What happened? We admitted it is. There's a Anjan, you give that order sheet.
There was no previous admission.
And the appeal was listed before this court for the first time on 5th March 2025. Subsequently adjourned, subsequently again listed on 2nd July 2025 to enable the appellant to file a supplementary affidavit and raise substantial questions of law. This direction was complied with today within bracket 10/7/2025, and the appeal was heard out on merits and has been allowed by this judgment. The question which would now arise is whether the order and direction issued in WP 748 of 2006 dated 10/3/2010 is feasible of compliance. The answer to this question should be a definite no. By efflux of time, the direction cannot be complied with, and as of now, the direction has become unworkable. Since the court directed an inquiry to be done whether the imported goods contained an embryo or a live organism, and the factual inquiry was required to be done upon notice to the appellant/writ petitioner, and after giving them an opportunity to counter the evidence of the revenue and to produce his own evidence in support of his contention. Admittedly, the product which was imported was a living organism, and though it is stated across the bar that representative samples have been drawn by the department, it cannot be disputed that those samples will not be in the same condition as on the date of import. That is date of import. Date of import is
volume 3, 328.
That is in August 1998. Thus, as on date, the direction issued by the learned single bench is not feasible of compliance. Having held so, the only conclusion that can be arrived at is to direct the department to accept the classification as adopted by the appellant.
Very great.
And accordingly, there will be a direction to the adjudicating authority to accept the classification as adopted by the appellant by classifying the imported goods under heading 2309.11, is it? No, according to you, 2309 point your classification.
To 3.09 and 5.11 is the
2309.90 and extend the benefit of the relevant notifications in favor of the appellant/importer. This direction be carried out by the concerned authority within a period of 3 weeks from the date of receipt of the server copy of this order. If the direction is not complied with within the time frame, then the court will be constrained to take serious note of the same, and the concerned officer will be held personally responsible. No cost.
Very grateful, my lord.
Deeply obliged, my lord.
For your lordship rise, my lord.
My lord.
For your lordship rise.
Ah.
I was praying that item numbers 10 to 13.
Ah.
Your lordship takes it any day, not tomorrow, my lord. Any other day next week.
Not tomorrow.
My
That suits me also.
My lord takes it up on Tuesday. 10, 11, 12. Because I am interested in this to get a stay because there's a contempt pending in the Telangana High Court. Now, Telangana High Court, there was a writ petition. This is a gold smuggling case.
Contempt pending against Kolkata officers in Telangana.
In Telangana.
It is a nice place to go. Should go to the High Court.
The export is from here. Everything is here. They filed a writ petition there and
In
release
fact,
of
they are developing that court complex. Some of them have been there. They say excellent facility, but of course it's little deserted after 6 p.m. because it's situated outside. Amravati is now being developed. And it's a wonderful building to be seen.
That is
and they've got good food arrangements.
Good canteen.
Jharkhand
also, my lord. High Court
Jharkhand
is
superb, sir.
superb. High Court. But my lord takes it up on Tuesday.
Any date. Subject to convenience.
Some precedence, if possible, my lord.
But today, because of Chaudhary and Manasi, we got stuck in this.
My lord.
Because if we don't do, then we will also be party to the delay. Okay.
Deeply obliged, ma'am.
Deeply obliged.
Yes, please.
May I be permitted to mention one restoration application? This is an SLSA matter, my lord. Appeal from service. SLSA.
Appellate side, Delhi list, Del number 1 and 2.
May I please your lordship?
This is the matter you mentioned. And when you will be ready to, he wants some more.
I can argue.
Because we have got fresh ambitions also. We'll have it sometime next week, Monday or Tuesday.
Both appeals. Our appeal and
Yes, both appeals. Immediately after fresh cases.
Serial number 3.
I'm grateful, my lord.
For the respondent petitioner.
Yes.
Appealing worship.
Yes.
But page 256 is the order improvement. 256 of the stay application.
I'm for that. On the bank, this is regional rural bank, my lord. The bank filed this appeal, my lord. Against that, my lord, the respondent, my lord, bank initiated disciplinary proceeding. My lord, charge sheet issued. Thereafter, my lord, inquiry has been done. The competent authority passed the order. Thereafter, he preferred an appeal. Appeal authority passed the order. And subsequently, my lord, it is before the trial court, court below, my lord. And the impugned order is from page 256 of the stay application. The court below, my lord, the entirely, my lord, set aside the charge sheet and my lord, disciplinary proceeding. And my lord, in the meantime, the petitioner, there is a scope to initiate proceeding, even my lord, retirement. If there is a regulation that 45 that disciplinary proceeding can be conducted as per the order of the court during the pendency of the after retirement. It is also not done by the court below, and there is a financial loss occurred 1 crore 71 lakhs by the bank, but the entire thing is set aside by the court below, my lord, and against that bank, the bank has challenged this, my lord. I prefer this appeal, my lord.
Then we have to hear the appeal.
My lord.
And where is now he is retired.
Retired, my lord.
And
you would have withheld all his benefits.
everything.
My lord.
Kindly see, my lord, the order passed by a previous proceedings by the Honorable Division Bench at page, my lord. Page 221. Page 221.
So everything was quashed and the matter was sent back to the disciplinary authority.
And with some observation to consider afresh. Kindly take the consideration page 226, only one paragraph.
224.
226 starts from page 226. Only recording, this is nothing but a psychostyle of the previous order. Same. Only facts have been narrated, then my lord kindly turn to page 232. Second paragraph. Keeping the above contention in my view. No consideration of my reply, the deposition, nothing. Nothing but psychostyle copy of the previous order, which has been quashed by the revision bench.
Where is the previous order?
My lord, I'm coming. Just a minute. Page 190. There's also 3 pages. Petitioner retired from service 30th May 2014.
See, up to page 228.
My lord.
It is verbatim.
Verbatim.
Thereafter, from page 228, paragraph 3, the discussion starts. Correct?
But these are the recording, my lord. Kindly see. No findings.
No, record reveals so and so 3.
Inquiry report.
Paragraph 4 is the points which you have raised.
My lord.
Paragraph 4, A, B, C, D, F up to N.
Yes. Page 228.
230, paragraph 5, you refer to a circular issued by NABARD.
My lord.
He says that NABARD circular is only a guidance. Non-compliance is not, it is not mandatory in character. Para 6, contended by way of not conducting through a superior by not providing him submitted.
No independent findings. What I brought to your lordship notice, kindly see no independent findings. Whether disciplinary officer has done rightly or inquiry officer has done rightly or guideline has not been followed. These are the findings. So you kindly come to 231, paragraph 8. So for acceptance of the report of the inquiry. As it appeared from this is the recording of the findings of the inquiry officer. No independent findings. 10 pages reply to the report of the inquiry officer, not a consideration why he is not accepting my views.
Where is that reply?
My lord. Just a minute.
183.
183.
83.
183. ঠিক বলছিস তো? All points I have taken. Starts from page 183 up to page 187, I think so. My lord, 188. Not a single line has been considered and spared by the disciplinary authority as to why my views has not been accepted.
Judgment of approval, or judgment.
Let us see the inquiry officer's report.
My lord, that is page, just previous document. Finally come to page 160, it starts from page 161, the communication, covering letter.
My inquiry officer report 178.
178.
What is the punishment which was imposed?
Reversion to the lower stage of initial payment.
Page 193, my lord, punishment.
Then why are you withholding all the benefits?
Not withholding, my lord. He's retired and get benefits. The final order passed 2016, my lord. Appeal passed by the authority. He filed the case in 2019. He himself filed. He got, my lord.
No, whether the gratuity and other
Yes,
things.
yes, everything is got.
That possibly has given. I am wrong. Possibly I am wrong. I stand correct.
Given, my lord. This is different.
So far, this part is concerned, I stand correct, my lord.
Because, my lord, 2014, he
reversion to the lower stage with initial scale of pay.
This is the punishment, my lord. Not withholding. There is nothing in the punishment, my lord, withholding anything.
Kindly go through the entire judgment of the learned single judge. All points are elaborately considered, even the subsection.
Then we'll admit the appeal. Let it be pending.
All documents are there.
All right. admit the appeal, then you dispense with the paper book.
But no paper book is required, my lord. All documents are there.
So we will dispense with the filing of paper.
No matter to appear. No matter will appear.
It will appear
Any day.
in the hearing list. Deepesh should give a date.
Man.
Yeah, I'm getting it.
Monthly list of September.
Man.
Okay.
Here number 4.
Okay.
And for the applicant.
Yes. Yes, sir.
My lord, kindly let us go to straight page number 525.
Page number
525. Order dismissing the writ petition.
we'll take it from this.
First page actually.
Yes.
My lord, the second paragraph starts, the petitioner claims to be engaged by the Damodar Valley Corporation DVC on some days on a month. This is utterly incorrect. On some days of a month, he continues to be engaged as such. So this is not the correct fact. So in fact, it is incorrect. Then my second incorrect fact is, the petitioner is admittedly a casual employee and or a bodily worker. My lord, to be a bodily worker, the post must be a sanctioned and permanent post. Other than sanctioned or permanent post, a bodily worker cannot be engaged. So this point actually goes in my favor. If I am a bodily worker, then I deserve to be permanent for serving long 25 years. So this is correct, not correct factually. Then my third point, my lord, at the end of this paragraph, for the huge length of 25 years of engagement from time to time, and the spike. A queer moment, my lord. From time to time means what? My lord, I submitted the entire documents of my service by submitting the bank statement, because my payment is made through bank.
But how to adjudicate these documents in a writ petition?
My lord, yes.
Because if he is a workman,
yes,
then if you approach the industrial tribunal, you could lead evidence.
My lord, I am coming to that point. Come to that point. My lord, I am not dismissed, not discharged, not terminated. Being a single workman, I do not have any way to go before the tribunal. I cannot raise industrial disputes. My dispute cannot be referred under section 10 if it is not supported by a group of workmen, substantial number of workers, or supported by trade union. I am a single workman there. I am working in a shift cycle with 2 others, permanent staff. I don't have any union, nothing. So how can I go before the tribunal, my lord? If court sends me to the tribunal, well, I am ready to go. But I think that will be against the statute, my lord. That is I have judgments for that, my lord. Group 10
The respondent, nobody is appearing. Who appears for the respondent?
My lord, Mr. Kallan Samanto, Jayanto Samanto, the other day he stood here. He told, I followed the MAT number, I could not follow the FMA number, but I sent him emails by citing the FMA number. He received it. He was present there the day before yesterday. He was present here when my lords were taking through virtual mode. He was present here. Yesterday, he dropped. because of the, because no adverse order would have passed yesterday. They're not coming. I think they don't have anything to say. My lord, this is the judgments, synopsis of judgments, ratio of judgments, my lord. These are given on 4 headings. So, my lord, first headings is par incurrum. I'm not coming into this. Then, my alternative remedy. I'm not coming into this. Then, my lord, on individual dispute. Second page, my lord. Individual dispute can be industrial dispute if taken up by union or a substantial number of workmen only. There are several judgments. Now, my lord.
But in their affidavit in opposition,
yes,
it has been stated that the petitioner was not continuously employed, but he was engaged purely on need base.
That will be proved by my submissions. I have submitted the records only.
But how to adjudicate on those records?
My lord, if the alternative remedy is not available to me, the door is closed to me. My lord, kindly come just for 1 minute. Kindly come to section 2A of the Industrial Disputes Act. Section 2A, my lord. There is another book for. My lord, the ratio I have given, serial number 6 and 8, the judgments were of 1957 both. That is before 1st January 1965. My lord, on 1st January 1965, amendment was made and Section 2 capital A was added to the ID Act 1947, my lord. Section 2A reads, my lord, may I read it? Section 2A. Section 2A.
Yes.
Section 2A, my lord. Dismissal, etc. of an individual workman to be deemed to be an industrial dispute. 1. Where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is a party to the dispute. So, before 1957, these judgments were 57th judgment. The situation was, if any individual workman was dismissed for any reason, he could not raise any dispute unless it was supported or espoused by his union or substantial number of workers. Substantial number of workmen, there are so many judgments, minus Demakuchi state judgment and Newspaper Express judgment, there are so many judgments. My lord, we may also see the definition of workmen. My lord, kindly see section 2S, definition of workmen. It is related with this point, my lord. 2S. May I read, my lord? Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purpose of any proceedings under this Act in relation to an industrial dispute includes, this is important, my lord, includes any such person who has been dismissed, discharged, or retrenched, so and so. So, person who is dismissed, discharged, retrenched, he will also be workman, even if he is not in the employment. But my case is not different, my lord. I am in the employment. I am neither dismissed, not discharged, not retrenched. So, how can I raise my dispute? Through Section 10 of the ID Act. It is contrary to statute. Then, my lord, kindly come to Section 10. To raise a dispute, to refer a dispute under Section 10, Form A has to be filled up, my lord, Form A. So, if we see, my lord, Form A, the Form A has to be signed by the Secretary of the Union. If the workman is dismissed or discharged, then he can sign. But if he is not discharged or dismissed, he cannot sign, or by a substantial number of workmen. So, what will be in my case, my lord? Who will sign it for me in the Form A? My way out. Should I be a legal orphan, my lord? Don't I have any way out, my lord? So that is why, my lord, I think Reed Court is the appropriate place. Reed Court is not completely denuded of its power. Reed Court is the appropriate place because what I have produced are the documents, are the records. Because they denied. They told, my lord, if we go, they told that I have worked only in few days in a month. So we may apply the falsity in omnibus. If they are false in this point, yes, I have not worked only on few days, on few months. I have worked for last 20, now it is 27 years, continuously. What is the documents, my lord? My bank statement. Through bank, my payments has been made. Each and every day, full payment has been made in every month. What I have documents, annexed, the provident part statement. I have no NCP days, non-contributory pay days. Even if I am absent for one day, it will be non-contributory pay days. There is no NCP days are zero. Every month, my full PF has been paid. So, my lord, this has been given only to prove that no, I am working continuously in a perennial nature of job for last 27 years. And my lord, if I say what type of perennial job I have given, my lord, I am working in 3 shifts where 2 other persons are permanent staff. And my job is very much important to the DBC's operations, my lord. I work in the operations room where series of batteries are there. I take up all the battery readings because, my lord, if there is a shutdown suddenly, then through the DC current system, it copes up with the circuit. If I do not maintain that circuit, the whole DBC's transmission line will be shut down. And my lord, sometimes happens, I have given in my pleadings, if someone in the other shift doesn't come, then I am directed to, yes, my lord, to continue in the shift. I don't give any overtime. For continuing the other shift, I don't get any overtime, nothing extra payment, nothing else. Because I am, my lord, at the receiving end. My lord, in the name of casual worker, I am just a subterfuge. Nothing more. Don't I have any inspiration, my lord? For the last 27 years, my lord, so many judgments are there. I have given, my lord, the views of the Supreme Court nowadays are transformational. But there is a great paradigm shift through the judgments of Sri Paul, judgments of Jaggo and others. My lord, kindly see. There is a great paradigm shift. The Supreme Court holds the Madhavi's judgment cannot be licensed to the authorities to exploit the labor. So what can I do? Where can I go, my lord? This court is the only hope to me.
Did you file a reply to the affidavit in opposition?
Pardon, sir? Yes. That opposition, the magic is, my lord, it was a magic that affidavit in opposition, its reply was bulky. So the learned single just told, oh, it's a very thick and thin. Then he did not bother to see in it. Within 5 minutes, his lordship, 5 minutes, gave the judgment. That judgment which is assailed here.
No, where is the reply to the affidavit in opposition?
Yes, there is, my lord. My lord, affidavit of opposition, reply to the affidavit of opposition, page 203 to 506. 203 to 506. Volume 2 and 3 both combined. Annexure C. Page 203 to 506.
But this aspect was not considered by the single bench, that you cannot raise a dispute under 2A because there is no dismissal, removal, or reduction in rank.
Yes, my lord.
And you cannot raise a normal dispute unless it is a collective.
Yes, my lord.
That point was not considered by the single bench.
Unless it is collective dispute, my case is not a collective dispute, so I cannot.
What we are saying is, in the writ court, this impugned order, this ground was not considered. Correct?
Court consider current.
My lord,
Court did not consider it.
See, you raised an issue regarding maintainability of the writ petition. Before which forum should he go?
Well, before that, my lord,
in the writ petition, he has annexed and he has admitted that he worked in a need basis. Sometimes he was.
But he's got tons of document to show that continuous employment.
Kindly consider the writ petition itself. The annexure shows he has annexed. That is not my document. I have not annexed. He has annexed in the writ petition and says that he has been engaged on a need basis. Sometimes for clearing jungles, sometimes for fencing, sometimes for battery work, sometimes for doing all other things. On 4 days in a month, 5 days in a month. This was the situation.
My lord, let me show. I ask through your lordship to show it.
All right. Let us assume, for argument's sake, he is employed on casual basis, on need basis.
Need basis.
He now seeks for regularization based on certain documents. According to him, bank statements are there, some communication. Before which forum he should go? He filed the writ petition. You said writ petition is not maintainable. Then before which forum should he go?
Industrial tribunal, 2S support similar. 2S malad. Now work has your lordship got it, malad. 2 subsection S malad. Workman means any person, including apprentice, employed in any industry to do any manual skill, unskilled skill, technical operation, clerical, supervisory work for hire or reward. Pausing here for a moment, my lord. This clause up to this is suffice.
No, he will fall within the definition of workman. But his prayer, he is not a dismissed workman. He is not a.
That is coming. My understanding, that is coming later on. If we pause here for a moment, within that ambit, he is falling under that.
Right. Now, where is his remedy?
Before the industrial tribunal.
Or what relief?
Lord, if he is entitled for retrenchment or for regularization, for that, if he is praying for regularization.
But he can't raise an individual dispute. He can do it only under 2A, 2 capital A. For that, either he should have been dismissed, where an employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman. Any dispute or difference between the workman and employer connected with or arising out of discharge, dismissal, termination shall be deemed to be an industrial dispute, notwithstanding that no other workman or any union workman is a party to the dispute. But there is an amendment, West Bengal amendment to section 2A.
Yes.
Where the words refuses employment has been inserted.
Which amendment, my lord?
West Bengal amendment. In the bottom it is.
My lord, West Bengal amendment is applicable if the appropriate government is government of West Bengal. In my case, in DVC, government of West Bengal is not the appropriate government. Appropriate government is central government. So West Bengal rules will not apply here. There are so many state government rules that will not apply to the government of India's organizations, my lord.
Decision. 58 Supreme. But you will fall within the definition of 2K.
My lord,
2K.
2K.
Because the word any person has to be interpreted. And there is one decision which is cited in this book also, AIR 1958 SC 353.
2K.
Means
Yes.
any dispute or difference
Yes, my lord.
between employers and employers, or between employers and workmen, or between workmen and workmen, which
Yes, my
is
lord.
connected with the employment or non-employment or terms of employment or with the conditions of labor of any person.
Yes, my lord.
Supreme
My lord.
Court says,
My lord, kindly see the word workmen. This MEN, not MAN. I have gone through this. I have gone through this many times, my lord. It is between the employers and his workmen, not only one workman. So by this definition, my lord, I am excluded.
but in a writ petition, how to direct regularization? We wish we could do.
Even if, my lord, after that,
There are more than 200 Badali workers in the High Court.
my lord, that is the curse to them, and they are not before the court. I am before the court.
Some of them have moved the court.
They should come, my lord. They should come.
But Supreme Court says, of course, the recent decision says that that is, you have also referred to that 2025. Huh?
Sripal.
My lord, kindly see the 12 number Jaggo. Jaggo versus Union of India. That is the most important at this moment, my lord.
Where is that judgment you have got? Copy is there? No.
Yes, yes, I have got the copy. Yes.
Then we will hear the appeal. What else?
My lord, one more thing, my lord. The order was passed 28/11/23 and the appeal was paid for 19th September. In the meantime, my lord, no section 5 perhaps I have not received the copy of section 5, my lord.
Is there a delay in filing?
No.
Order was passed on 28/11 and the appeal was preferred on 19th September 24.
Which order? Which order? No delay.
May I hand over the copy of the judgment, Lord?
No, impugned order. Was passed on 28/11/2023.
My lord. And appeal was preferred on 19th September 2024.
In between there was scan. In between there was scan 1 or 2024 for recalling the application. What my lord friend is saying? He is skipping the can in between, which was also dismissed.
And my lord, we were slapped on cost as your lordship stated, my lord, 3,500, and it fell from the lordship.
Right now, he said one recalling application.
Who filed recalling application?
Recalling? I filed recalling application.
Before the single bench?
Yes, my lord.
After dismissal of that, you filed an appeal.
Yes, my
And
lord.
my lord,
Yes.
what happened, my lord? When I came up with the application, my lord, well, I'm sorry to say, it fell from his lordship. What order sheet you have got? You have come here. If you are agreed, you prefer an appeal. My lord, there is a provision that that we can come up with application for recalling and modification. And my lord, 3,500 were slapped on the show motor, your lordship state that order. We did not pay any application for
Now, whether this person is still working on casual basis?
Yes, my lord. I'm working.
Let him continue to work.
I have no instruction with regard to that. Lord. I don't have the specific instruction. Whether he is
No,
still
citing the dismissal of the writ petition, don't disengage him from.
I
No,
don't
there is no
have the
disengagement.
Lord.
There is no disengagement as such. But I am appealing for my regularization. For the last 27 years of my service, my lord, I deserve to be regularized, my lord, because I am doing day in and day out the same work which my colleague who is permanently is doing. There is no difference. Perennial job. There is no dot top job. There is no one top job. I am doing the same work.
But you are 100% sure that he is still continuing to work?
Yes, my lord. Yes. He is continuing. He comes to my home every day. Even day before yesterday also
he
comes.
comes from Rupnarpur. He's in that bill. He was, my lord, out of court, my lord, say he was a very senior officer in Hindustan Cables. He's in the know of things, my lord. He knows each and everything, which we are ignorant of that, my lord.
DBC
That's
just
my learned junior's argument. And my lord, what claim one legendary judge of our High Court, just Alok Gupta, nobody is wiser than the statute. And another legendary judge, Justice Ornilson said, when the statute is clear, we need not be crazy about decisions because judges may be as but the statute cannot be. When I say we may be as but the statute cannot be. This is my Justice Anil Kumar was the legendary figure of Calcutta High Court. And he said, and Justice Alok Gupta said, nobody is wiser than the statute. And Justice, it fell from his lordship. And my lord, when another senior advocate, Mr. Somenson was arguing, well, here's the father of Anil Gupta, just on the boss, my lord, sitting there. And my lord, you see, Mr. Sen, my lord, we are junior, my lord. We are junior. We attend the court. My lord, I was present, my lord, during those days, my lord. And it fell from his lordship. And the second up, Mr. Bosch, Mr. Sir, your swan song will not do. Your swan song will not do. When the statute is clear, we need not be crazy about decisions. Judges may be as, but the statute cannot be. It fell from their lordships. And my lord, these two judges were legendary judges of Calcutta High Court.
Well, one very objectionable point my learned friend mentioned that in my pleading, I mentioned that I am engaged on need-based. Where did I plead it? My lord, kindly come to page 21. Page 21. Initial jobs were.
No, if they plead that you are engaged only on need basis, they have to prove.
No, yes.
Person who pleads has to prove.
Now, how
you
do
are given documents, bank account statements to show on a monthly basis you have paid remuneration.
But that is another issue, my lord. He said that in my pleading, I told I am
Yes. I will satisfy your lordship. I will satisfy lordship.
All right. When you will argue the appeal?
Fix any date, subject to lordship's convenience.
My lord, just
I was
humble prayer, my lord. Very humble prayer. And kindly dispose the matter when your lordship is here, my lord. We are very much safe before your lordship. Safe and secure before your lordship.
So the initial terms of employment, the initial jobs are not the guiding factors up
You
to
please prepare one dates and events.
It's prepared. Already prepared.
Dates and events.
Yes.
Well, he has done meticulously well all these things, my lord.
Then it will be easier for us to.
Give me order, I will prepare.
No. If it is already there, then
yes. Already there. Several representations are there. Pages are there. I can cite just page numbers.
All
right now.
Let the appeal be listed for hearing on 24th July, immediately after fresh cases. It is submitted by the learned advocate for the appellant that the appellant continues to be engaged as a daily wager
Daily wage basis.
As engaged on a daily wage basis.
Paid monthly. Paid monthly. Yes.
Daily wage basis, but his remuneration is paid on a monthly basis. Until date, he is continuing in employment. During the till this appeal is heard and disposed of, the services of the appellant should not be disengaged, and he shall be continued to be employed on a daily wages basis.
But that is not my prayer, my lord. I am already.
Sir, they will terminate you, sir. The moment your writ petition is dismissed, no interim order is there, immediately they will send you home. Without asking, we have passed this order.
Grateful, my lord. Grateful, my lord. Grateful.
That is what all these mighty managements will do.
Grateful, my lord.
You lost before the learned writ court on the question of maintainability. They are waiting for what will happen in this appeal. The moment the court has not granted stay, from tomorrow onwards, they will say, don't report. So you should have made that prayer.
Yes.
So you continue to employ him.
Lord, kindly clarify if continuing, if he continuing.
Even if it is not so, you continue.
No, we are still in the open court. We are submitting that he is continuing.
My instruction is this, my lord. I cannot say.
Kindly record it, my lord. As well.
It's all your decision, sir. If you want, you can tear off the record. If you want, you need not maintain any record.
That is not.
You will say attendance will not be maintained. Those people have got no bargaining power, sir. Can they go and meet your officer? They can't meet them.
They can, my lord.
Let this order be there. Next.
Thank you, lordship.
Deep blue black.
Call. Meeting another 5-10 minutes.
Lord, this matter, my lord, I am praying for not this week, my lord. In the meantime, I have on humble submission before the Lord. See, there is an administrative order which was not within our knowledge, but I have got the order from the website. In the order, my lord, there is an order, the certified copy, which has been annexed, I got from the department, my lord. Here is my lord certified copy.
Now it is annexed. It is here.
Yes. No, certified copy in the Rekha Banerjee, my lord. Rekha Banerjee, who has already expired. Before the Honorable Single Bench, my lord, Honorable Justice Amrita Singh, a substitution application was filed. Then appropriate order was passed, and an order was passed. Direction was given to the department to correct the usual order. But it has not been most probably corrected, my lord. The certified copy, my lord, expired, my lord.
Order of substitution was there.
Yes.
Despite that, it has not been recorded in the order.
Yes, my lord.
That is what.
Then my lord, suddenly it has been noted, my lord, that actually expired, my lord. But file, my lord,
whose name has to be substituted?
Substituted, my lord, those the appellant. Mother expired, my lord. Mother name is there, my lord. The mother expired, there will be expunged, my lord. The daughter is there first. No, if possible, up to your lordship, that is up to your lordship satisfaction, single bench order, writ petition is all for my lord, single bench, writ petition, my lord.
The name of the first writ petitioner.
See, actually the registrar admin has passed an order saying that the name of the petitioner number 1 is not there. Petitioner number 1 was the mother.
In the appeal, my appeal,
daughter, mother of the.
In the writ petition.
Yes, my
mother. So she is no more. So therefore, yes. Aparna Thakur, Suparna Banerjee, Joyanta Banerjee. Yes. So we will regularize that.
Yeah, regularize, my lord. But the order was there, but it has not been.
That order, when that order was passed?
Most probably in the year 2009.
You have that copy of that order?
No, my lord. I tried to get to our website. My website it was not there.
So in the writ petition itself, substitution was ordered, yes. But it was not carried out.
Yes.
Not actually a substitution. The original employee died. The writ petition was filed by his legal heirs. One of the legal heirs has expired during the pendency of the writ petition, so the
Writ petition continues in respect of the other legal heirs.
Who was the original writ petitioner?
Mahadev Banerjee. No, yes, in the earlier writ petition, my lord.
Not the legal heirs were the writ petitioners.
Don't confuse, sir. Sir, in the writ petition, the first petitioner was Rekha Banerjee. She died, leaving behind the petitioners 2, 3, and 4 as the legal heirs.
They were also there. They were also there.
Correct.
Yes, my. They are also.
Other than these 3, there are no other legal heirs.
Only, my lord, Rekha Banerjee's name will be expunged.
Right.
The registry has raised an objection, stating that the name of the first writ petitioner, Srimati Rekha Banerjee, does not find place in the cause title of the appeal memorandum. It is submitted by the learned advocate for the appellant that when the writ petition was pending, Srimati Rekha Banerjee died, leaving behind the writ petitioners 2, 3, and 4 as her legal heirs. And those 3 legal heirs are the present appellants. It is further submitted that necessary substitution was ordered by the learned court, but it appears that the order has not carried out by the department. Therefore, the defect pointed out by the registry stands clarified, and the present cause title, as reflected in the memo of appeal, shall be accepted. What else you want?
No, I do not want anything. That is actual, this is the actual fact, my lord. I am submitting. This is the position.
In the cause letter says cannot hear. Can is. At the request of the learned advocate for the appellant, let's next week. Next.
Serial number 6.
Only short point involved in this matter, my lord.
Who will appear for respondent?
Mr. Partho Ghosh was appearing.
Delay we condone.
Yes, my lord.
Where is Mr. Partho Ghosh?
Yes.
All right, let him appear. We'll say not today.
Your lordship.
Or Monday. When it will come? Monday.
No, my lord. I have
Tuesday.
Tuesday.
We have heard so and so. None appears for the respondent. List on Tuesday. Next.
Number 7.
Lord, I am appealing on behalf of the writ petitioner.
I await for the appellant. This is an appeal from an order passed in a contempt jurisdiction. May I place the order passed in the writ petition, Your Lordship?
But the last question, my lord, directed first of all, my lord, maintainability of this appeal.
I will kindly take page 131.
Yes.
Order dated 19th of January 2021. The writ petitioner was impaneled as a casual worker on the basis of number of days worked as on December 31, 1986. He had worked for 225 days. By an order passed by a coordinate bench of this court in WP number such and such on August 28, 2014, the writ petition was disposed of, directing absorption of casual employees from the said panel against permanent vacancy or for the purpose of any further casual engagement. The petitioner was not a party to the writ petition. A contempt application was filed by the petitioner for violation of the order dated 28 August 2014, which was dismissed. The matter was carried in appeal in MAT 1381 of 2017, which was dismissed as withdrawn with liberty to file afresh and self cause of action. An application under 136 and application under Article 136 of the Constitution was moved before the Honorable Supreme Court in SLP 41318 of 2017, in which on November 4, 2019, the Honorable Supreme Court, setting out the operative part of the order of the single bench dated 28 August 2014, inter alia held that while there could not be any contempt against DVC, the latter was still obliged to comply with the order dated 28 August 2014. Similar orders were passed on November 3rd, 2015 in Civil Appeal 13766 of 2014. was also relied upon in this regard. The said SLP number 26224 of 2019 and IA of 2019 were filed by the DVC seeking modification of the order of the Honorable Supreme Court dated November 4, 2019. The said IAs were disposed of by the Honorable Supreme Court inter alia orders dated 5th February 2020 and March 2, 2020. The orders dated March 2, 2020 is set out herein below. Hard learned counsel for the parties, we are appealed to notice the untenable plea taken by the applicant for not giving effect to the order dated 4/11/2019 passed in SLP number such and such in its letter and spirit. The stand taken by the applicant, to say the least, is preposterous and an attempt to circumvent the directions issued by this court on 4th November 2019 and further clarified by the order dated 5th February 2020 passed in the miscellaneous applications under consideration. No further elaboration is therefore required. We direct the authorities to comply with the directions contained in the aforementioned orders without any exception within 2 weeks from today. No further indulgence will be shown to the concerned authorities who are obliged to comply with the same. Failure to comply would result in having committed aggravated contempt of the court, which will be viewed sternly. We place on record our disapproval about the tenor of the affidavit filed in response to the order dated 5th February 2020. We find that the affiant has not disclosed this specific fact noted in the order dated 5th February 2020, which he was expected to disclose in the peculiar facts and circumstances of the misapplication rejected with the aforesaid directions. Counsel for the petitioner would argue that a plain reading of the orders of the Honorable Supreme Court passed in SLPs referred to herein above would indicate that in substance and essence.
No, ultimately, the single bench held that because of the direction issued by the Supreme Court, you are bound to comply with the direction.
Yes.
You have not filed any appeal against the order passed by the
in this writ petition. Yes.
Where is
DVC
that
preferred an appeal that was later withdrawn because we had complied with the order. We have
now, what is the contempt?
Yes, if you will kindly see the operative portion of the order, which is at page 138.
We have got this memo of appeal.
Yes.
Which paragraph?
Page 138, the last paragraph. Starting with, in view of the above, this court holds that the writ petitioner is entitled to be absolved against any vacancy in the Group D post commensurate with the nature of work he has performed in the DVC, and DVC is directed as such. With the aforesaid observation, the instant writ petition is allowed. This is the order passed in the writ petition. After the DVC preferred an appeal, subsequently DVC complied with this order, and the appeal was later withdrawn. Now the order was complied with, and he was absorbed in service, and after after he was given a probationary period of 1 year, he was later made permanent. Now he prefers this contempt application, and the order passed in the contempt application, you also will find.
Lord, may I interrupt for a moment? Well, Lord, order passed by the single bench. Well, Lord, after order passed, a contempt application was moved. During pendency of the contempt application, a stay application before the Honorable Appeal Court was moved. The stay application was disposed of without granting any stay. My Lord, thereafter the final hearing of appeal came up before the last justice presided over by my Lord Justice Bosha. My Lord, what happened? Several hearing was made. My Lord, 7 to 8 days, my Lord, hearing was made. Thereafter, the DVC suddenly withdraw this appeal. Withdrew this appeal. Then again, contempt application was moved and order was passed. Order was passed. My Lord, kindly see the order of the contempt application, my Lord, page.
Against that order, you are on appeal.
Yes, my Lord. Against that order, they have come
before that, your Lordship will kindly take for once page 143, 146, and 147. 143 is Lordship.
This is the appointment order.
Yes, 143 is the appointment order. 146 says that in pursuant to paragraph 3 of the respective appointment order dated such and such passed by the Honorable High Court at Calcutta, in such and such, the following junior manager is hereby confirmed as junior manager with effect from 8th March 2023 after successful completion of 1 year period of probation on 7th of March 2023. So after completion of the probationary period, he was made permanent. And on the next page, your lordship, page 147, this is a charge memo, where your lordship will find the signature of the respondent also that he has accepted the appointment. Now, after being observed in service, he files this contempt application. Now, the order passed in the contempt application, your lordship will find at page 195. It's an order dated 21st of February 2025. The order dated 29 January has been collected as follows. Lordship, kindly take from paragraph.
You are aggrieved by that 2014.
Yes. Because a parent order passed in the writ petition never contemplated benefits from 28th August 2014.
This is outside the scope
Yes,
of the.
and this issue has already been clarified by the Honorable Supreme Court.
Petition with effect from 1986.
No.
My prayer was made.
Prayer was made
And
prayer you'll pray
yes,
for the sky.
heaven. Well, my lord, kindly hear me.
It is a fresh cause of action.
No, my lord,
Number two, are you not stopped from doing so after having accepted the order, accepted the employment, and got confirmed in the post after completion of probation? See, if your service had to be regularized and appointed and regularized with retrospective effect, the question of probation will not occur. You accepted to be a probationer for 1 year.
My lord, kindly consider.
You file a fresh writ petition.
My lord, kindly hear me for a moment. My lord, the writ petitions prayer, this effect from 90 panel was published. My lord, what happened? The writ petition is allowed. My lord, certain modification in the contempt application, my lord.
See, if the no doubt contempt jurisdiction is curative. Suppose there is an order of injunction, some fellow has been thrown out in violation of the order of injunction, restitution is possible. But this relief the court did not grant. But the court in a contempt petition said, for the length of service, calculate from 28th August 2014.
2014. My lord, kindly hear me for a
We will not foreclose your right. We will say, see, because if the direction issued is outside the scope of the writ petition, then it's an error apparent. Clause 15 appeal is maintainable. Therefore, it is not an appeal under the Contempt of Courts Act. No punishment has been inflicted.
Yes,
Section 19. Therefore, a regular appeal, contempt appeal will not lie. But a clause 15 will lie.
Clause 15.
There is a.
My lord, can invoke the clause 15 of this letter written. But my lord, kindly hear me for a moment. My lord, the Supreme Court, my lord, kindly see the Supreme Court's order. My lord, 3 orders passed by the Honorable Supreme Court.
Correct, sir. Therefore, that is why they accepted it. They tried to argue before the single bench, everything gone, and ultimately they withdrew the writ petition. I mean, appeal.
My lord, writ petition, my lord, kindly see the order of the London single judge, page 169.
He did not grant that relief, sir. Sir, let us face facts.
Not.
Where is the impugned order? I mean, in the writ petition order.
Page 131.
130, 174.
The operative portion is at page 138.
In view of the above, this court holds that the writ petitioner is entitled to be absorbed against any vacancy in Group D post commensurate with the nature of work he has performed in DVC, and DVC is directed as such. With the aforesaid observation, the instant writ petition is up. So, what was the prayer in the writ petition? Please show.
My lord,
page.
Writ petition with not me, my lord. That's it.
Oh, it is not here.
Not here. My lord, one thing.
Prayer must have been from original.
My lord, thereafter is subsequent development. My lord, what happened? A group of employees of the Supreme Courts, my lord, they filed an edit application. But as a casual worker, regularization on Form 2020. Thereafter, my lord, hold the London court below, they hold that the 50% of this
past service
counted on the basis of this according
that
to the
is why
sentence.
you should have filed
A judgment was delivered. A judgment was delivered. According to that, they are not pay fixation on the same date on 2003. My lord, that's contempt application pending, and they have passed an order to implement the order. My lord, some mathematical calculation.
So whether this writ petitioner was a party in that writ.
That writ petition was pending. Because, my lord, the one writ petition, a group of the same.
So you file a fresh writ petition.
Yes.
Get your writ petition tagged along with that and pray.
Already, well, that already judgment was earlier.
So you say it is covered by judgment
and contempt. On the basis of that judgment, my lord, the GBC already passed an order.
So therefore, it's a fresh cause of action, is what you are saying.
I am not asking. I am praying before your lordship. That is the 2003. My lord, the petitioner name also. Yeah.
We will leave it open for you to claim that you should be absorbed retrospectively, because there are some other decision. In a contempt petition, that cannot.
They have already passed that order.
So you take advantage of that.
2003. 2003, they have already, but they have not fixed the pay. This is the problem.
One submission, Lordship. This order, the order passed in the writ petition, was not appealed against by my learned senior friend. He has not preferred an appeal. He was not agreed by the order. He could have preferred an appeal. Now in contempt petition, he says that no, give me the benefit retrospective effect. That cannot be. He should have preferred an appeal. No.
All right. This appeal filed under clause 15 of the letters patent is directed against an order dated 21/2/2025, passed in CPAN 81 of 2025 in WPA 10271 of 2020. The learned advocate appearing for the respondent writ petitioner raised a preliminary objection as regards the maintainability of this appeal, stating that in the order passed by the learned single bench in the contempt petition, no order of punishment has been issued, no punishment has been imposed, and therefore this appeal is not maintainable. As mentioned above, this appeal has been filed under clause 15 of the letters patent, on the ground that the order and direction issued in the contempt petition goes beyond the scope of the order passed in the writ petition, namely WPA 10271 of 2020. If that be the case, an appeal under clause 15 of the letters patent is maintainable against such an order. Therefore, we are required to see as to whether the order passed in the contempt petition travels beyond the scope of the direction passed by the learned single bench in the writ petition. The case has had a very checkered history, and there has been earlier round of litigation. Matter travelled up to the Honorable Supreme Court on 2 earlier occasions. Ultimately, the Damodar Valley Corporation, the appellant herein, thought fit to withdraw their appeal in MAT 224 of 2021 and decided to implement the directions issued by the learned single bench. At this juncture, we take note of the direction issued by the learned single bench, and it would suffice to take note of the operative portion of the order dated
the 19th January 2021.
19th January 2021, which reads as follows. Sir, page 138, sir. I'm marking with pencil. 138 and 130. Thus, it is pointed out by the learned advocate for the respondent writ petitioner that the respondent writ petitioner had filed the writ petition seeking for benefits from the date of initial engagement on casual basis on account of his continuous employment. Though that might have been a prayer in the writ petition, the direction issued by the learned writ court is to absorb the respondent writ petitioner against any vacancy in Group D post commensurate with the nature of work he has performed in DVC, and DVC is directed as such. And with this observation, the writ petition was allowed. Therefore, it is clear that the court did not fix any particular date from which the length of service should be computed. However, in the contempt petition, for the first time, the learned writ court held that the appointment of the respondent writ petitioner shall take effect for the purpose of length of service from 28th August 2014. This direction, in our considered view, is beyond the scope of the direction issued in the writ petition, and virtually the orders passed in the writ petition has been modified, that too while considering a contempt petition wherein the allegation was that the appellant DVC had violated the direction. It is pointed out by the learned advocate appearing for the appellant that after the intra-court appeal was withdrawn by DVC, the DVC has implemented the order passed by the learned single bench and appointed. Where is that appointment letter you showed?
Page 143 and 146.
Appointed the respondent writ petitioner as junior messenger, by appointment offer dated 7/3/2022, and he was placed under probation for a period of 1 year. On successful completion of the probation, by office order dated 6/12/2024, he was confirmed in the post of junior messenger within bracket group C/D bracket close with effect from 8/3/2023. After successful completion of 1 year probation period on 7/3/2023. Therefore, the order passed in the contempt petition calls for interference. Accordingly, the appeal is allowed and the order and direction issued in CPAN 81 of 2025 dated 21/2/2025 is set aside. However, we do not propose to foreclose the rights of the respondent writ petitioner, as it is a submission of the learned advocate for the respondent that other similarly placed persons had filed a writ petition seeking for benefits from the date of initial engagement, and the learned writ court had passed orders to the effect that 50% of the past service will be taken into consideration, and certain orders have also been passed by DVC. Therefore, we leave it open to the respondent writ petitioner to work out his remedies in accordance.
DVC already passed the order, all the casual employees, those that appointed regularized. My lord, DVC already passed the order from effect from 2003.
Remedies in law by approaching the DVC by way of representation seeking for similar relief. In the event it is not granted, it is open to the respondent writ petitioner to take recourse before the appropriate forum, the appropriate matter.
Too late to come. I'm so sorry.
No problem, sir.
Because this matter, my lord, your lordships have been pleased to accommodate me for so many days. So I told him that do the matter.
Yes, he did a good job.
Yes.
My lord, very next matter, my lord, kindly keep it in the next week, my lord, instead of tomorrow.
Next.
Item number 8.
What's the next?
Item number 10 and 11. My lord, kindly take it up next week.
Who's appearing?
Item number 10, I'm appearing.
And 11, I will inform Mr. Churaria is there, my lord, I will inform him.
In item number 10, there was a direction for me to submit records to the court. Kindly, can I submit? There are
what records are these?
Lordship, the original petition filed before the tribunal.
These are the
petition
compilation filed by the. You are for the respondent or appellant? Appellant in item 10 has been filed, which is taken on record. Okay. Whenever you want to take.
Tuesday.
Tuesday.
Grateful, Lord.
Very auspicious day.
My
That
lord,
is
13, 14 and 15, my lord. Insurance appeal. If the stay is not granted, my lord, the appeal.
We want to see your grounds.
My lord.
Have you raised the what is his name? Huh? Rajesh Singh. Mr. Rajesh Singh, you know?
Tuesday.
You don't know?
Yes.
He is also for the national insurance.
Yes.
We have admitted 2 of his appeals, granted stay. You find out on what ground we admitted. Initially, he also didn't raise that ground. We asked him to raise that ground. On that question of law, we have admitted.
My lord, I have raised the ground on employer-employee relationship. I have.
No, another ground. You check up. You prepare and bring that ground tomorrow or Monday.
Fine.
Monday.
One
My lord, item number 11, my learned friend, just again.
Tuesday, you want.
Tuesday.